objections that you're considering that have to do with last month's hearing. That's what she's here for.
Got it. Thank you. Well, we're glad you're here. All right. Mr. Young, will you make your public disclaimer?
I will.
Thank you.
Good morning. I need to do a public disclaimer at the beginning of the meeting. The meeting date and time and location have been noticed on the TN Real Estate Commission's website, included as a part of this year's meeting calendar since July 1st, 2015. Additionally, the agenda for this month's meeting has been posted on the TN Real Estate Commission's website since Thursday, March the 31st. 2016. Also, this meeting has been noticed on the tn.gov website since Thursday, March 31st, 2016. Thank you.
Thank you. Now, if you'll call the roll.
Okay, roll call of the commissioners. Johnny Horn.
Here.
Fontaine Taylor.
Here.
Gary Bloom.
Here.
Diane Hills.
Here.
John Grease.
Here.
Janet DeShera.
Here.
Marcia Franks.
Here.
Bobby Wood.
Here.
Austin McMullen.
Here.
You have a full commission today.
Thank you, Mr. Chairman. I'm going to ask Commissioner Horn to lead us in an invocation. And if you can figure out some way to mention Gary Bloom in that invocation, I think it'd be appropriate. And then when we're finished with the invocation, if you all will stand, Commissioner Horn will lead us in the pledge to the flag. Commissioner Horn.
Well, Father, we do thank you for this privilege of being able to do the King's business, and we just ask you, Lord, to bless in a special way, give us clarity of thought, clarity of mind. Most of all, Lord, understanding where understanding is due. We pray also, Father, that you would be with all the commissioners, their health, their driving. And we thank you for having Brother Bloom back with us, and we just ask you to bless in a special way. We thank you now in Jesus' name. Amen.
Amen. Please stand.
Pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you.
Thank you, Commissioner. Our friend Commissioner Bloom has been out for a few months battling all kinds of maladies. But he's strong enough to drive up here or get up here from Memphis this morning, and I understand you're going back if this meeting ever gets over today. So we're thrilled. We can't tell you how happy we are you're back.
Thank you.
All right, next up is to approve today's agenda.
Motion to approve.
I have a motion by Commissioner DeChara, seconded by Commissioner Hills, that the agenda as submitted
Mr.
be
Chairman.
approved. Ms. Franks.
I'd like to add something to the agenda. We've been giving out either coming to the Real Estate Commission meetings or education, and I would like for us to talk about what would be appropriate for principal brokers as far as that education. If we could add that somewhere.
Okay, at 1:15 or thereabouts, we got a commission discussion on various topics.
That'd be fine.
I'd like to add it there. And how would you like to caption that again?
Principal broker education.
Any objection to that request? All right, with that objection, that's added to the agenda. Other items to add, modify, or delete? All right, I hear none. Let's vote on the motion to approve the agenda as amended. If you're in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Ms. Franks. All right, next up is to approve the minutes of last month's meeting.
Move to approve. Second.
I have a motion by Ms. Franks, second by Ms. Hills, that last month's minutes be approved as submitted. Discussion. All right, if you're in favor of the motion, vote aye.
Aye.
If you're opposed, no. Excuse me, that motion passes unanimously.
Mr. Chairman, I abstain.
One abstention from
Two abstentions.
one abstention from Mr. McMullen and one abstention from Mr. Bloom, for a total of 2 abstentions. Any other modifications to the vote total? All right, I don't hear any. Mr. Chick, you ready to go?
Good morning. It's
Or whoever.
motion, so I'll
You're on the, perfect. You can stand, sit.
Whichever one you choose, just make sure you're close.
This.
Pull it close to you.
May it please your board, my name's Sharon Jacobs here with the Nashville Bar on behalf of.
Go closer to that, please. Thank you.
Let's so, excuse me, Ms. Jacob, is it
Yes.
Jacobs?
Jacobs, yes.
Okay, just for the audience's information, Mr. Chick is with the Office of Legal Counsel, Department of Commerce and Insurance. Ms. Jacobs is with the Nashville Bar. Is that how you're
I'm
identified?
with Bone McAllister Norton, a member of the Nashville Bar here on behalf of Spencer Lindahl.
Okay, thank you.
We have to give you the whole.
So procedurally, what's about to happen?
Oh, yeah, Mr. Chairman, she filed on behalf of her client two motions. So normally what happens is, it being her motion, she will go first and present her motion.
I get two attorneys in front of me. I just
pretty
need you to tell
scary,
me
isn't
how
it?
it's supposed to work.
Imagine how we feel.
I'll tell you exactly how it's supposed to work.
Okay. On behalf of
kidding.
Mr. Lindahl, Ms. Jacobs.
I've been sitting where you are before on a different board. So I filed a motion to stay your order, which was the demotion of his broker's license and the civil penalty until this matter can be heard by the Chancery Court. And I also filed a petition for reconsideration to ask this board to reconsider setting a contested case hearing on this matter because of so many inconsistencies in the record. And I understand you have the option, and I'm sure your counsel will advise you, to either deny the reconsideration or agree to set it at a later date. The reason we believe reconsideration may be more appropriate here is because going to Chancery Court, while we will actually file and ask for a stay there, we believe there's a whole bunch of constitutional issues here that due to the record and due to the lack of service. And I listened to your all's hearing yesterday, actually, the entire thing, and noticed that several of you noticed that as well. I'm here today to tell you, I can tell you the stuff that is not what we consider proper notice under the UAPA, which is the Uniform Administrative Procedures Act. And under the Uniform Administrative Procedures Act, all notices are supposed to be sent pursuant to 62-13-314. And this is going into my petition for reconsideration, actually. We believe the ALJ erred when she advised you and pretty much cut off Mr. Lindahl, saying that she didn't believe that statute applied. That statute is specifically for non-resident brokers and reciprocity for service of process. And specifically, 62-13-314B1 says that service by the director of the commission, any member of the commission, any of that has to go to the last address that he put on that form. And Mr. Lindahl did submit that form to you all as proof and to the department that that was his last known address. You also looked at a computer printout during the hearing that had that address on it. And there was a discussion on there that, well, there's both on there, and the last one that says ML is the one in Memphis. Well, with all due respect, his home office was on there, and with the date, as the form that's required under the statute, and that's where service should have been given. Aside from that, the other evidence is that the email chain between Mr. Lindahl's two assistants and this other realtor specifically states that they're acting on his behalf. It's from his email address, And it says contact us. Not anywhere does it say contact me or I have authority. There's no acting as a broker by either one of those, although you only found for one of them. And the definition of broker and acting as broker is found at 62-13-102 4A, and I bet everybody on this board knows that way better than I do. But we believe the evidence, you should reconsider it and set this for hearing, because the evidence will show you that those email strings are actually a back and forth out of his email address from him, and they say us. They never say me. And further, neither one of those people are compensated as a broker under the definition under 4A or act in that manner. And finally, I would bring to your attention that under the rules of conducting a contested case hearing, which are found at 1360-04-01. Those are contested case hearing rules. Service of process or filing of a document is defined under the definitions as, unless otherwise provided by law or by these rules, filing means actual receipt by the entity designated to receive the required materials. Well, the record is pretty clear that Mr. Lindahl didn't receive the first notice from you all in August. Now, granted, he did receive later notices, but he also did not receive the information that was presented to the board timely under the notice issued by the ALJ to submit exhibit lists and witness lists. And I understand there's an email issue, but under the rules, email is not delivery. While it can be used as proof that you had actual knowledge, delivery is not an acceptable service of process. And finally, I would say, I venture to guess that most lawyers, most realtors do have their own email address, and the fact that my assistant may sit down with me over her shoulder and say, this is on behalf of Sherry Jacobs' attorney, if you have any questions, please contact her. That is not negotiating, that's not practicing law under the rules, and therefore we would submit that that's not the acting as a broker here. And finally, I would say that the punishment was unduly harsh based on this commission's prior rulings. And I know there was discussion saying we want to get his attention, that these out-of-state brokers need to, know our rules, and we appreciate that, and I believe he would be willing to do, as Commissioner Woods said, perhaps do some CLE or whatever you all call it, continuing education, but demoting his brokerage license for someone sending his one email that specifically says, this is on behalf of Spencer Lindahl and contact us, from his email address seems to be harsh to demote his brokerage license, which would then cause him to have to notify every other state that he is licensed in that there's been an action taken. And for those reasons, we ask that, one, you issue a motion to stay on the enforcement of your order, and these are two separate motions, so you can make a decision either way on either one of them. That you, on the motion to stay, that you stay the implementation of the demotion of the license. He's happy to pay the fine, but it's the demotion of the license, and if that is the way you want to split it, and two, that you set this for a contested case hearing at another one of your regularly scheduled meetings, so we can present the evidence from these individuals who can attest to exactly what I've said.
So procedurally, is it appropriate for us to ask Ms. Jacobs questions at this time, or to listen to your presentation first?
You would ask her questions, or I could give you my side. Maybe let me speak, and then you can ask both of us questions if you want to do it that way. That might be more expedient,
It's new ground for us, so if there's a procedure, we'd like to follow it, but if there's not, if you two are in agreement that Mr. Chick talk and then we'll ask questions, that's fine too.
One's fine with me.
Okay, Mr. Chick.
Okay, well, good morning, Commission. My name is Adrian Chick, Assistant General Counsel for the Department of Commerce and Insurance. And before I really get into to respond to the two motions that are before this board, I think it might be worthwhile to point out that in contested cases such as this one, there's actually three agencies that are involved. Number one, there's the Tennessee Department of Commerce and Insurance. That's my employer, that's my client. The Tennessee Department of Commerce and Insurance was the petitioner in this contested case, so that's one agency. And then there's the Real Estate Commission agency. And generally, unless specified otherwise, when the Uniform Administrative Procedures Act or the Secretary of State's rules for hearing of contested cases, which she referred to, when either of those speak of agency, they're speaking of the Real Estate Commission, because if you go in the front of the UAPA definitions, it explains that an agency is any state board commission that has the authority to determine contested cases and do rulemaking. So please just don't confuse me as being you know, because you're the agency that has the authority. And then the third one is the Administrative Procedures Division. They're an agency, and their involvement is that they provide us with an administrative law judge. So that being said, I don't have much to say as far as her the merits of what she's saying as far as she believes the punishment was too harsh. I don't believe the state requested anything particular at the hearing. I feel like my job is to give you the facts and the law, and that's your decision, and that's how I feel about that now. But as far as Ms. Jacobs' comments about the due process, constitutional, that I do want to respond to that. And I believe part of what's going on here is there might be a confusion between what's a contested case where due process is involved and what's not. And maybe some of this will also be for the benefit of Mr. McCullen, who wasn't at the hearing, but the first complaint, the administrative complaint, was sent out, I believe, July 31st was what was in the record. There's no contested case at that point. That's an informal proceeding. Until the notice of hearing and charges were filed by me at the Secretary of State in February, there was no contested case hearing. But once that happened, yes, you have those documents, pleadings have to be served.
I'm
Yes,
sorry,
sir.
could you, I missed the very beginning part of what you said. What was the informal procedure, and what was the formal procedure?
What's at issue? One of the things at issue is that he was sent a complaint by the staff, which allegedly he didn't respond to within 10 days. That's not.
And when was that? July?
Sorry, July. The letter was dated July 31st, 2015.
Okay.
That's the one that the state alleged he didn't respond to, that resulted in part of the violations. But all the stuff back then, that's not contested case. That's not UAPA stuff. You know, we don't get into the UAPA until the notice of hearing and charges are filed.
That happened in February?
That happened in February. And I believe it's quite clear that he obviously did receive the notice of hearing and charges. He participated in the hearing. He certainly never objected to it, so I believe if there was any objection to that, I believe he waived it. But I mean, that never came up. So procedurally, I don't think there was any problem. As far as exhibits and things like that, I can assure this commission that Judge Mary Collier, had she believed that I had failed to provide something I should have provided, I can assure each of you that would have been made known. But she told the commission, she told the respondent, you are responsible for getting your exhibits here. The problem is you're not here. you don't have your exhibits here, it's not Mr. Chick's responsibility to do that. So with that being said, I understand that this commission's options are three, basically. The commission cannot take action on it, which means after 20 days, it's deemed denied. And this is the reconsideration motion. Or the commission can take action by saying, okay, we're going to reconsider it right now, and you could right now decide you're going to issue a new order. Or you could decide that you're going to set this matter for further hearing and hear whatever issues you decide to issue, what you decide to take up. But the commission would need to identify what parts you are going to consider if you do that. I don't think we need a new contested case hearing altogether. I'm not sure. I don't want to misquote her, but as far as the motion to stay, if the commission found and they made a public policy statement, you made a public policy statement that it was necessary, I would submit that it's necessary or it's not. So, and they have to. The respondent has to ask this commission for a stay before they can ask Chancery Court for a stay. So. This is a prerequisite to them asking in Chancery Court for a stay. But anyway, if there's any questions, I'll be glad to.
Ms. Hills and Ms. Franks. Go ahead.
Ms. Jacobs?
Yes.
If I understood in your statement, you said that your client had submitted proof about delivery. And I do not recall, so did I miss something? I did not recall anything being submitted by him during the hearing.
Right, it wasn't submitted during the hearing. It was submitted prior to that. And unfortunately, I mean, we always disagree, obviously, but I believe the ALJ changed, and my client sent the information to Mr. Chick, but I don't know that it was ever sent to the ALJ. And in fact, I don't know that the ALJ's order was ever sent or received by Mr. Lindahl because, again, it kept going to this Memphis address. So, yes, I would agree that, there was a big discussion about this July delivery. But even after he notified everybody, this is my home office, this is where I receive everything, it still all kept going to Memphis, which creates a lag time. And the notices had, 6 and 7 and 3 days before the hearing to submit documents. So he did submit it by email to Mr. Chick, but he did not submit it to the ALJ, is my understanding from the testimony.
But it was not submitted to us during the hearing?
You all actually did review
by
it.
your client.
It was an exhibit. Exhibit 6, maybe?
I believe it was read. Is that correct? Are you talking about the consent to suit form?
Well, I thought you were, the consent to, the consent to suit form was read and then cited with the statutory authority. I don't know that it was attached. It was an attachment of one of those documents that was an exhibit, but it never was in the record.
So it was submitted by the state, not by your client to
It was
us.
submitted by my client to the state and then read into the record, but you did not have a piece of paper in front of you during the hearing.
Thanks.
Ms. Jacobs, I'm wondering why, number one, what was his name, Mr. Lindahl? Mr. Lindahl gave up his right to have an attorney present. And in doing so, Judge Collier continued on with the hearing. We had to make a lot of things for him easier. He called by phone. He did not even appear himself. So it wasn't important enough to even show up. It wasn't important enough to have an attorney. But now that he has had his license changed, he now is maybe seeing it's important. And for that reason, I would say we've already gone over this. We gave it ample time. We had a judge here involved. We don't have all that information before us today. We just now remember bits and pieces. So I think it's unfair for us to do anything different today. And I would not be voting for anything that would change the judgment that we had.
Okay, I have a question for each of you. So, Ms. Jacobs, is it your client's position that he's okay with the $1,000 fine, that he's okay paying the hearing cost, he's just not okay with the license downgrade? Is that the issue? Everything else is okay, so that's what we're focusing on.
If we cut away the law and all the things that I'm alleging, then yes, at the end of the day, that is true.
That's the issue.
That's the issue.
Okay, Mr. Chick. So Ms. Jacobs, I think in her testimony or presentation to us, said that it was her opinion that ALJ erred in her interpretation of TCA. Do you dispute that, or do you agree?
I will dispute that. I believe she read that. She's talking about the consent to suit form, and that's another thing I don't quite get where the harm is with regard to exhibits, because we went up and got stuff for him and read it in. The commission, with the help of Judge Collier, correctly determined that is consent to sent. That is a form that says if you're out of state, you can be sued in any county of the state of Tennessee. But it doesn't mean that whatever address you put on that little blank is the only address that the commission can use. I mean, the commission has a specific statute that tells where we have to send notices. That's 62-13-313 that says it's supposed to be sent to the last known business address. And the evidence was entered that's, again, he's got a Tennessee license. That was the 5050 Poplar Suite 1430 address. So.
Ms. Jacobs, so this to me, it's a serious allegation. If an administrative law judge erred, I don't know that I'm capable of knowing whether that's true or not.
I understand that, and unfortunately, I mean, that would be one of my errors in Chancery Court, and unfortunately, then you all are the ones who have to defend that. And I still beg to differ on the statute, because everybody read the beginning of that definition, but if it goes on to say that any member of this commission or the director of the commission, that the consent stipulating that service of process or pleading shall be taken in all courts to be valid and binding if personal service is given at that address that he filled out on that form.
Ms. Jacobs, which statute are you reading?
62-13-314-B1. And the judge looked at the first sentence and dismissed it, even though a non-lawyer raised this, saying, hey, this was always what I thought. I always thought, that I filled out the proper form. Here's my signature. Here's a proof of it. And that it says that if he got service there under the law, he got service of process. I don't care if he's moved and disappeared, but if it went to that address, then absolutely you've got service of process under the law. It's mandatory. It doesn't say it may be service of process. So in that regard, I believe the ALJ, again, because the ALJ switch, just kind of looked at it and dismissed it. Having said that I believe that was an error that was not the fault of anybody in this room.
Mr. McMullen.
Ms. Jacobs, could you just enumerate what is it that you're asking us to reconsider?
Well, I'm willing to negotiate.
No.
No, I'm asking you to reconsider your downgrading of his license.
Okay. And that's based on you think that, or he believes that penalty was excessive?
I believe it was excessive. It's not consistent with your other orders. There was plenty of evidence in the record that was overlooked with regard to what that one email really said, and your own rules on your website pretty much lay out what an assistant can or cannot do, and I would submit that this assistant did what you could. So I believe that the penalty was excessive, not the monetary penalty, the downgrading of the license.
Okay, I understand what you're asking for there and your reason for it. Is there anything else that you're asking us to reconsider?
In the event that you don't reconsider it, then we're asking you to stay your order until we go to Chancery Court.
Is there anything else that you're asking for today?
No.
Okay. What is the standard that we're supposed to apply when deciding whether to stay some or all of a final order?
Are you asking, who are you asking?
I was asking Ms. Jacobs, but she can phone a friend or anybody can chime in if they know what it is. I'd rather get to the end as soon as possible.
45312.
For stays?
Yes, for stay.
Yeah.
And what does that say?
I'll read it to you if
Okay.
it's okay. 45316 says the party may submit to the agency a petition for stay of effectiveness of an initial or final order within 7 days after its entry, unless otherwise provided by statute or stated in the initial or final order. The agency may take action.
You got 316?
Yes.
So that sounds like the time period and how you do it, but can anybody tell me what the standard is that we're supposed to consider on when we're deciding whether or not to grant a stay?
I don't believe there are any standards in statute. I don't believe there are any standards.
Ms. Jacobs, do you agree or disagree with
I
that?
do agree, and I've done these for 25 years, and no one's ever asked me that question.
Okay. Well, so why do you think we should stay the effectiveness of the downgrade?
Because of the implication it has on his license, it's inconsistent with your other orders, and it's so excessive.
Okay, Mr. Chick, you disagree that we should grant the stay? And why, I assume, and why is that?
It's really two different things. What I'm saying is if you are steadfast and feel confident you want to stick with your final order, then I don't see considering public policy, I don't see why you would stay just while they go to Chancery. Now, as far as she's suggesting that the downgrade part be taken out, I mean, the state doesn't have any position on that. I mean, that sounds reasonable to me, but.
You're talking about the reconsideration request,
Right.
though? Okay. On the stay, do you have a position on whether we should stay the effectiveness of that part of the order? I thought I heard you earlier to say that there was a finding in the order that it was public necessity that we do this.
Right, and that's what I was saying was that it's, if a commission says, okay, we think that as a matter of public policy, we need to take this action to protect the public, then why would you turn around and say, well, they're not going to be endangered while he's appealing? It's just, that's the way I would look at it, but I think it would also be fair to consider what are the chances of the respondent being successful on appeal.
I mean, the typical stay factors include likelihood of success on the merits and likelihood of irreparable harm and things like that.
Right.
And I heard Ms. Jacobs refer to, I think, kind of insinuate some irreparable harm, I guess, to his business. He's not going to be able to continue to practice until he finds a new principal broker.
Well, no, he has to notify every other state he's a broker in, and that would be irreparable harm to his business. I agree with you in court. A motion to stay has those standards, and if we go to Chancery Court and you don't reconsider or issue a new order, then I'll file a motion to stay there too, and then I'll I'll allege those. It's just before the board, it's pretty much up to your discretion.
All right, so Mr. Horn and then Mr. Bloom.
So I'd like to ask, first of all, let me clarify, I'm not a lawyer, and I don't speak lawyer. So if you could explain to me, I mean, I don't want to feel like I'm being held hostage, you know, you do this or we do that. And what good would a stay do if he's getting ready to go to Chancery Court if I don't? I don't quite get that.
Well, the statute says we have to do it. It's sort of like, you know, the rules that you and I agree with or disagree, the government tells us we've got to do. One of those necessary steps is I have to file a motion to stay and ask for the stay in order to go to Chancery Court and ask them to stay it. So I don't have a choice in that regard. And he doesn't really have a choice of whether to ask for it or not because it's detrimental to his business. So to answer your question, the law requires me to do that as like taking the test to get a driver's license. You have to take the test at least once, right? And it's the same. We have to file a motion to ask you to do that, to give you the opportunity to do it before we go to the court. And I agree with the Commissioner McMullen, is that right? That irreparable harm and all those are things that you all may decide to consider. Again, with regard to this specific matter, this email was to another real estate agent. This was never to the public. And so to say that the public would be harmed, I don't even make the connection. That would be something that you would consider, obviously, if you didn't want to stay. You'd say, oh, he's been out there, you know, letting these people post signs with their faces on it all over town and coming into Nashville trying to, you know, buy up real estate with somebody who's not a licensed broker. But that's not what happened. There was one email sent. So to say that there'd be a public harm, I think is, I just don't see the connection. Does that answer your question?
Mr. Bloom.
Yes, Ms. Jacobs, you indicated that the downgrading of the license of Mr. Lindell was inconsistent with our previous actions. Do you have some reference that would show that someone who came before this commission or was asked to come before this commission and snubbed their nose at us and did not come, we did not downgrade their license? Do you have that?
Well, I don't know that there's any record of anyone snubbing their nose. I think Mr. Lindahl would take exception to that depiction, and unfortunately, he didn't realize the UAPA process. I granted.
You said it was inconsistent, so evidently we've done something in the past that was different from what we did to him.
Right. What I've looked at is just whether or not an email constitutes downgrading a broker's
No, I'm asking
license.
if somebody was asked to come before this commission and refused to come before the commission, did we downgrade their license or did we not?
I'm not aware of any, and he didn't refuse to come before the commission.
He didn't appear.
Okay, I would like to step in there and say that I don't believe the commission can penalize him in any way for the fact that he participated by telephone, if that's what we're talking about. The administrative judge at the beginning of the hearing, she went through the statute and said, okay, by statute, as far as the telephone goes, if the respondent agrees, if the ALJ agrees, if the state agrees, and if the commission agrees, then he can participate by phone, and everyone agreed. So that I don't think that can be.
I think what Mr. Bloom is asking is, what specific have you found, date, case, or whatever, that's inconsistent? Or maybe I should ask this. How many, you said you watched the video yesterday, the YouTube of our last meeting. How many meetings prior to that have you listened to?
A couple, like two.
Okay, and so in one of those two, did you see that we did something that was incorrect?
No, absolutely not. I'm not asserting that at all.
So you really are saying that we were doing something that we don't normally do to other people when you have no evidence of that fact at all. Isn't that correct?
No.
What is your evidence?
Well, I'd say the public record reflects that one email has not prompted you guys to take that stringent of an action.
And maybe we've not had a case like that either.
That's true. I don't dispute that. So I can only go on the public record.
Okay, and you can't quote any public record at all. So that's really, you're just kind of throwing that out there to see if it sticks.
No, I think that
It's
if
not
a
sticking.
court, I mean, that's fine.
Okay.
Ms. Hills.
I have two parts. One, Ms. Jacobs, you said that your client would have to verify with every state that he's a broker with. What are you referring to? So I'm not.
I will tell you that is what he has told me, that if you downgrade his brokerage license here
In Tennessee. How
yes.
does it affect any other state license?
Well, that's the thing. Everybody's state is different. But if an action's been taken against you and a reprimand aside from a penalty has been taken in some states, he's telling me he's got to notify them. And I can't tell you what states because he's the one who knows all his states.
It's not clear on Tennessee very well. The other part is, and you keep referring to this one email, and I'm just like Commissioner Franks, because we don't have the exhibits here, and I'm only going on recollection, and your client was stating the part in the front of the state manual that, that's all right, that they can, about unlicensed assistants, what they can do, and he emphasized that. He missed the part what they cannot do. So if we were listening to what he was doing, and you keep referring to this email that I remember part of it, you're saying that it was referring to we or something, and that included him, but that would be your interpretation. I don't remember the wording, but it could also represent that it was that we, and I don't know if he was a seller's agent or buyer's agent, we are counter-offering this, or we could do this, and that would be delivering or acting as an agency. So I think, from my memory, you're referring to this one email being so ridiculous to have been considered. That email, in my memory, was pretty not following the rules. So if I'm missing something on this one important email, I need you to tell me.
I'll read you the email.
Okay.
And this is up to you. You're the commission who makes this decision, whether you agree or disagree. I'm just telling you what my perspective is. So absolutely, you're correct that you're the one who makes that decision. It says, "Hi, Robert. After receiving your client's rejection, the buyer's wish to raise their offer to $124,500. Please let us know if that is something your client could work with. Thanks. Kim Tampano, Property Acquisition Assistant for Spencer Lindahl."
And she does not have a license in the state of Tennessee
Right.
to negotiate.
Which is what she was doing.
And
that's
his
where he-
point was, in that first section, because I recall his testimony, and so if I use the section he was showing made it all right, then I would say it is for an unlicensed employee, assistant, or secretary may not discuss or explain listings, offers, contracts, or other similar matters with persons outside the firm.
All right, unless there are other questions, I propose that we'll talk about the motion to petition for reconsideration first. If that passes in some form, there's no need for a stay. Is that correct? Or would you have to have a motion for a stay following that, if it does or does not pass?
I think she's asked for a stay if we deny the request for reconsideration.
Right, but if we accept the reconsideration, not to reconsider it either today or at some future date, do we still need to stay at that point or not? That's what I'm confused about.
I guess if we went ahead and reconsidered it now and removed the downgrade, then
all
she would
moot-
not be
moot
asking for a
point.
stay, right?
All right, so the chair will entertain a motion.
I'd like to make a motion.
Related to the petition for reconsideration. Okay, Ms. Franks.
I make a motion that we do not reconsider this item before us today.
Second.
Okay, I've got a motion by Ms. Franks, second by Ms. DeChara. Now discussion, Ms.
Oh, that, I was going
Okay.
to, just second.
All right, is there discussion on the motion?
Restate the motion, Mr. Chairman.
It's a motion to not take this item up, basically, for lack of a better term.
I'll speak in favor of the motion. I don't think there's been a showing that the decision to downgrade was contrary to the evidence or law that the board considered. I don't think there's been any evidence showing that the decision was contrary to decisions the board made in previous cases. I don't think there's been a showing that it was clearly erroneous, and I don't think there's been a showing that there's been a change in the controlling law that would make it an erroneous decision. So I think it's proper to deny the motion to reconsider.
Other commissioners wish to speak to or against the motion? Mr. Bloom?
I'm just going to not vote since I wasn't here last month.
Other comments, discussion? The motion on the floor is to not take up this reconsideration petition.
Mr. Grease?
Yes, sir.
I apologize,
That's
sir,
all
for
right. We need
interrupting you, but I want it to be clear that is the motion to actually to deny the petition? Because there's a difference in denying it and deciding not to take any action on it a little bit.
Was your,
I don't want us to reconsider it in any way.
So
I'd like for it to be done.
do you
and
want to
denied.
deny the reconsideration petition? That's your motion. So,
Right.
commissioners, are you clear with that? The motion on the floor is to deny the petition offered by Ms. Jacobs for reconsideration. All right, further discussion. All right, let's vote then. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. Okay, I've got 7 ayes, 1 no, and 1 abstention. Now, is there a motion to stay the discipline related to the downgrading of the respondent's license?
I'll make a motion that we do not allow that stay.
Second.
That's a negative motion.
I know,
We
let's
can't
say,
do that.
your motion is to deny the request for a stay.
Yes.
Okay, I've got a motion by Mr. Char, and it's the opinion of the chair. The motion is to deny the request by Ms. Jacobs for a stay of the disciplinary action. Seconded by Ms. Taylor. So now we're voting on the request to stay.
Roll call, please, on that.
First motion or this next one coming up?
On the first one you just did. We might
Sure.
need that.
Sure. Mr. Taylor, Mr. Young,
Are we talking about the first motion that we already passed?
Yeah.
so just for the record, we'll have a roll call vote.
Okay.
All right. Roll call for the motion to deny the reconsideration of the petition. Johnny Horn. Fontaine Taylor.
Yes.
Gary Bloom. Diane Hills.
Yes.
John Grease.
Yes.
Janet DeChara.
Yes.
Marsha Franks.
Yes.
Bobby Wood.
Yes.
Austin McMullen.
Yes.
All right, the motion, that's for the record. Now we have another motion on the floor, which is to deny the request for a stay of the disciplinary action imposed in a previous hearing. We'll also roll call that, I suspect, and if you're in favor of that motion, you'll vote yes. If you're opposed, you'll vote no. Mr.
Can we
Young?
talk about it quickly?
Yeah, sure.
I think we should deny the motion for a stay. One of the considerations typically when you're asking for a stay is whether you're likely to be successful as you go on in the appeal. And I think based on what we've heard with the request for reconsideration, I don't think that there's a likelihood of success on the appeal. Another consideration usually is whether there's irreparable harm that's going to happen to this person from the final order. And there's been some kind of unspecific reference to the harm, but I haven't really heard anything specifically of what specific harm he's going to incur, other than maybe having to disclose this to somebody, but it hasn't really been specific as to what. Another usual consideration is the balance of the harms, and here the board did find that that there was a risk of harm to the public from him continuing to practice as a principal broker. And so I think the balance of the harms favors leaving the downgrade in place. So I think we should vote in favor of the motion to deny the stay.
Do you think that this allegation that the administrative law judge erred is not significant enough to?
Well, I agree with what the chairman said about that, which that was a finding of the administrative law judge, and we're not in a very good position, I think, to argue with the administrative law judge about the law on that. And certainly the respondent has indicated that they intend to go up to the Chancery Court and to ask for a stay there. And so the judge there would be in a better position to evaluate, I think, the legal merits or lack thereof of what the administrative law judge did. And, as basically the respondent has said, they'd like to get a stay from us, but they recognize that this is just a prerequisite to go into the chancellor to get a stay. So I think we should send the respondent on his way to the Chancery Court.
Mr. Chick.
I certainly don't mean to contradict Ms. Steen, but I believe that, in administrative cases, it's the job of the administrative judge to make, to determine questions of law, but the case law has made it clear that it's your ultimate decision. I mean, any decision that an administrative judge makes is always subject to your review. So if still you felt like that's her take on that statute wasn't correct, it actually is within your prerogative to do what you think is right on that. So
I guess just to clarify my point there, I had not heard a good explanation as to that was understandable to me as to why the administrative law judge made a mistake there. I think we've heard differing interpretations of a statute. To me, it doesn't appear clear that there was a mistake that was made. And so that's why I say that I think there's not a high likelihood of success on the appeal, but that'll be for the chancellor to decide. We're just sitting in the position right now of having to speculate as to what the chancellor might do. And based on what I've heard, I don't think the appeal will be successful, but that's ultimately for the chancellor.
And so your recommendation is what?
I was going to vote in favor of the motion to deny the stay.
I just struggle with this notion that to me that's a significant allegation, and I'm not qualified to tell you whether it's true or not, even after Mr. Chick gives me his take on it. I don't know.
Okay, can I clarify myself for just one point further? I think that the administrative judge, personally, I think she made the right decision, but I was just letting the commission know that if the commission members thought that she didn't make the right decision, yes, you could change that. In this case, I happen to think her decision was correct, but if you thought it wasn't, you shouldn't hesitate to.
If my memory serves me right, he was quoting out of the front of the manual about what an assistant could do and couldn't do, and we obliged him to take a break so that we could go up and make copies of what they could do and what they could not do, and we looked over that, and it was very clear that this was an unlicensed agent negotiating the price of a contract.
Other comments? The motion, if you vote yes, is to deny the request for a stay. If you vote no, then we'll have another motion if that passes. Mr. Horn.
I remember the case quite clearly. And one of the things that made me lean the way I did was something that was taken off the website against what was in the book. And now that's been dropped. I don't hear that. We're going by some email that's been sent to somebody, which I thought we had got that all straightened out. But websites sometimes do differ from what the official manuals say.
But they did not. They went and copied it out of the manual.
Yeah, I understand what you're saying. The thing about it, if they came away with the understanding, you know, he didn't read far enough, I can understand that he might need to go back to remedial reading. But the idea, again, I think he acted in good faith. That was, he thought he was following the manual and following the website. And come to find out, the manual was more explicit than the website was. And that was what I was saying. I think every unit out in the government has probably got websites saying something that the official manual don't say. Even in church, we got people saying things that the official manual don't say. So
For sure they do things
Yeah.
the official manual doesn't say.
So that's your argument that I saw and thought maybe we should not have taken the downgrade for the simple reason I saw a conflict between those two issues, and I just wanted to make that clear before we vote. What happened? Okay.
Thank you, Commissioner Horton. Any other comments, Mr. Wood?
Commissioner Horton, I think, you know, Mr. Lindahl was, when he was talking about the website, he kept referencing their website. So we stopped, went and got pictures of the website, brought it for everybody to look at. And the issue was he didn't read everything on the website. He just read the first part. He didn't read everything. And so, you know, again, it goes right back to sometimes somebody even in church, they don't read all of it. They read part of it. And I think that's what happened here. He just looked at part of it that helped the situation. The other issue I have, I think the big discussion has been over him being served for the process of all this. And I'm really not sure. There's been a lot of talk from him during his discussion. I heard him talk about he's in Arizona, if I'm not mistaken. And then he also talked about he's the broker in the Memphis office, and was asked about that. And I believe he talked about he was there quite often. And I don't see that as a normal commute between Arizona and Memphis. I'm just not sure if I believed all that. And that's what kind of leads me where I would vote for this motion that's coming. I'm just not sure where the truth came from. So,
All right, Mr. Young, unless there are other comments, let's roll call this, starting with Mr. McMullen this time.
Okay.
Work around.
Mr. McMullen,
Yes.
Mr. Wood,
yes.
Ms. Franks,
Yes.
Ms. DeChera,
Yes.
Mr. Grease,
Yes.
Ms. Hills,
Yes.
Mr. Bloom,
Abstain.
Ms. Taylor,
Yes.
Mr. Horn.
Right, that motion, which is to deny the request for a stay, passes on an 8-aye and 1 abstention vote. Ms. Jacobs, Mr. Chick. Ms. Jacobs, Mr. Chick, anything else to come before us today from your perspective?
I'm sorry.
That's all right, just checking.
We were talking about you.
Thank
No,
you
I'm-
for your time. We appreciate it.
All right,
And
thank you for
your
coming in.
service to the state.
All right, ladies and gentlemen of the audience, we have several individuals who are going to come before this commission today who have got some history. Some members of this commission likely have some history too, that, speaking for myself in particular, that would or could preclude that individual from getting a real estate license. So the law allows them to come with their principal broker in front of the commission and talk over what happened, why it happened, what they've been doing since, and also let the principal broker tell us why he or she is interested in having that individual as a licensee in his or her firm. So we're going to start off on a couple of those right now, and they'll be scattered throughout the day, assuming people show up when they're supposed to. First up is Kent Ledbetter, broker, along with an applicant, Joseph Mike Harris. Gentlemen, if you'd come up, let the law director swear you in first, and then have a seat near a microphone where you both can talk.
You both raise your right hand and repeat after me. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Very good.
Thank you. Mr. Young?
Okay, the applicant is Joseph Michael Harris. He intends to apply for an affiliate broker license. The principal broker is William Kent Ledbetter. He was first licensed as a broker in November of 2007 and became principal broker of the firm effective 3/31/14. Mr. Ledbetter is responsible for supervising 126 affiliate brokers and 8 brokers. There's been one complaint filed against Mr. Ledbetter in which he accepted a consent order for a civil penalty in the amount of $12,000 for an advertising violation. Another complaint filed against Mr. Ledbetter resulted in a letter of warning for advertising. His firm is Knoxville Premier Properties, doing business as Keller Williams Realty, number 260612, Knoxville, Tennessee. The summary of disciplinary sanctions for Mr. Harris. Mr. Harris pled guilty to a felony of battery in February of 2003 in Hernando County, Florida. He was sentenced to 4 years administrative probation. In October of 2007, Mr. Harris was granted restoration of civil rights by the Office of Executive Clemency in Florida.
Thank you, Mr. Young. Mr. Harris, at this time, we'd give you the floor, and you can tell us everything or as little as you want to tell us about what happened, when it happened, and what you've been doing since that time. And if you'd lean into the microphone or pull it to you as close as you can, we'll record this for everybody's future use.
All right. Well, basically what happened was I was living with a girl, dating her, and she was pregnant and came in drinking. She had been drinking several times, and we had argued about it several times. So the night that she came in drinking, we got in an argument, and she went into a rage and destroyed some things in the home. And as she was walking out, I slung, it was either a 3 or 4 inch statue off of our dresser and hit her with it. And I didn't mean to hit her, it was an accident. And as soon as I realized I hit her with it, I apologized, and she accepted my apology. So for approximately a month, we were together as a couple, and only when I decided to break up with her and to move out, she went down and filed the charges for it. So they put me on, they offered me a deal, the state did, and I took it because I had 2 children that I was raising alone, and I had already spent thousands of dollars, 2 attorneys, each $5,000 retainers, and the expense was just too heavy for me. And I was worried about what would happen to the 2 children if something happened and I went to prison for it. So I took the plea deal. But I never intended to hit her with the statue. And the reason it was considered a felony is because she was pregnant at the time.
Oh, would you like to tell us what you've been doing since that incident?
I took, during the probation period, I took an anger management course in Tennessee because I immediately moved away from there to get away from her. And I've learned my lesson. It was very expensive, and today I still feel sorry that I hit her with the statue, but I didn't mean to hit her. It was an accident. Is that what you meant?
Whatever you want to tell us is fine. Commissioners may have questions for you. Commissioners?
Okay.
Miss Taylor?
I have a question. It says you've been on disability since 1991.
Yes, ma'am.
You were hurt?
I worked for an explosives company in Florida, and I got hurt, and I've been out ever since then on disability.
And then it says you have a landscaping service now?
I don't. We've had several businesses on the side. One was a pressure cleaning, and one was lawn service. I don't do that now. The only thing I'm doing now is taking classes with Keller Williams.
Well, it says self-employed landscape lawn service.
I have done that in the past. I don't do it right now.
It says
All right.
what is, all right, so you don't do it now.
I don't do that right now. I have done, we have flipped houses. I've done that over the years on the side, flipping houses, and my wife and I have had rental properties that we've done rental properties also. And that was the reason that I was interested in getting into the real estate sales part of the real estate. I enjoyed doing it.
Other commissioners? All right, Mr. Ledbetter, why are you interested in having this fellow associated with your firm?
Gotten to know Mr. Harris over the past
we'll,
few months.
We'll get to you, Johnny. You can come back. We'll come back to him. Go ahead, Mr. Ledbetter, and then I'm sorry.
Gotten to know Mr. Harris over the past few months, and even though he's not licensed, we have he has been attending our training classes. We have training 5 days a week. It usually starts at 9 o'clock and till 2:30 to 3 o'clock, and it's 5 days a week. We have a training room that's about a third of the size of this room, and so we have extensive training, and he has been attending those and trying to actually, even though he's not licensed, trying to understand the industry and I know him, and he seems to be very honest person. I think this is just something that happened in his past that just was unfortunate. I think.
Commissioner Horn, if you'd like to go back to Mr. Harris for a second.
Yeah, just a couple of things, sir. Are you still under any type of court order now? Have you settled all your fees and?
Everything has been done for years. I think 2007, everything was finished with that.
You ever consider expungement?
Sorry?
Expungement of your record, your criminal record?
I looked into that recently, and they said that that even if I went through the process and spent the money to do it, that it would still show up. That once it was there, no matter if they expunged it or no matter what they do, it's still going to be on my record. Once it's on your record, it's on your record. It's a permanent thing. Contacted an attorney in Florida and asked them the same questions just recently, and that's what they told me, that they advised me not to do it, that it wouldn't help me any.
Let me back up for just a second here. You said you flung a statue at her.
I did.
But you didn't mean to hit her.
I didn't mean to hit her with it. When she came into our bedroom and went into the rage that she did this several times, but she picked up a guitar and started beating it across our furniture. And the reason that it aggravated me was it was my nephew's guitar, and I just had it to tune it and put strings on it and tune it for him. And it just crushed me because it was the last gift that his mom and dad gave him before they got divorced. So
I'm trying to determine what were you doing with the statue, trying to see how close you can get to her?
Oh, she walked out of the bedroom door, and I thought she had left, and out of aggravation, I just slung it off the dresser. I didn't pick it up and throw it. I didn't aim it at her. I just slung it, and she happened to open the door back up. I don't think she ever left the room. I think she was standing there and then opened the bedroom door. And I don't know for sure where it hit her. She just told me it hit her. And I apologized immediately, and she acknowledged that, that it was an accident, and it was never an issue until a month later after I decided to break up and end the relationship. We stayed together as a couple for approximately a month.
Okay, I just wanted to hear your version of slinging something at somebody.
I still feel bad today about hitting her with it. I would never hit anybody on purpose or hurt anybody intentionally. It was an accident, and to the day I'm still sorry.
But you completed your anger management.
Required by the court, the probation. I had that done within weeks that I moved to Tennessee back in '02.
you completed the course, but how's your anger? Is it under control?
Lately, you can talk to my wife. She's sitting right there. She'll have no issues whatsoever with my anger.
All right, are there other questions for
I'd like to make a motion.
Mr. Harris or Mr. Ledbetter? Okay, Ms. Franks.
I'd like to make a motion that we approve the applicant's request.
Second.
I'd have a motion by Ms. Franks, seconded by Ms. Hills, that the request of Mr. Mike Harris be approved and he be allowed to continue on his real estate career. Is there discussion on the motion?
Mr. Chairman, I think the convictions we're talking about really happened a pretty long time ago, and I don't think they implicate issues of honesty or trustworthiness or competence to transact business or respect for funds that are held in trust for somebody else. And we see that he's taken anger management, he shows remorse, and he moved away from the cause of the problem by getting out of the state. And so I think we should grant the motion.
Other comments? All right, let's vote. If you're in favor of the motion, vote aye.
Aye.
Opposed, vote no. I've got 8 ayes and 1 no. The motion passes, sir. You're free to keep on going that real estate career. Good luck to you.
Okay, thank you very much.
All right, thank you. Is Johnny McBowen here? Thanks, guys. Richard Rodriguez, are you here? All right, we're going to take a 10-minute break, and we'll be back right at about 10:30.
Serve a break today.
But I think you take care of that at McDonald's, don't you?
Just start doing that.
During our
Please don't
weekend.
Ross has got that.
Yeah, I am. I had my second treatment yesterday, and I just yeah, for which I'm very thankful.
And you're familiar with this buyer? Okay. Uh-huh. Huntington, uh-huh. Yeah. Okay, all right, that'll be fine. Okay, thank you, Gary. Bye-bye.
The pastor last time I checked, I think the name was still out the other side.
A lot to be said for that.
Yeah. No. Hey, sometime, she was up here the last week.
Okay, I just have to, I just need to figure out how to do this. I'm in Nashville today. I'll be back in.
I appreciate you mentioning me in prayer, too.
Hey, man, we've been doing some tall prayer for you, brother.
Thank you. Thank you very much.
Yes, sir.
Priceless. So they know what he looks like. Okay, so warrant for his arrest in Colorado?
It's in Colorado. Mal
Priceless.
Hey, John.
Our two primary positions. In this game.
I don't know, my friend.
You're up for whatever, huh?
I'm down for lunch.
Okay.
I think it's delivered. He's trying to embarrass
I think so too, Jim. I think he's trying to get me. See, I caught my foot right there.
Amendment, that would get everybody to sign it. Notifications only signed on one side.
Apparently so.
Yeah.
I wonder if they were here. Did they sign in, do you know? I guess it wouldn't matter.
Well, the applicants don't.
All right, let me ask again. Johnny McBowen, you in the building? Richard Rodriguez. How about Floyd Love or Perry Hamlet?
Well, nobody's coming to see
All right,
us.
let's, Commissioner, I'd like to move down to a topic that's scheduled for 1:15 this afternoon related to commission discussion items. We've got now 5 bullet points to talk about with the addition Ms. Franks added, principal broker education. So let's see what we can get done between now and the time one of those applicants shows up. Mr. Young, do you want to start the discussion on the first one?
Sure. On the expired reinstatement, which is 1260-01-.21, and I'm actually bringing this out with the expired license due to failure to comply. As part of your provisions with this, you require that after an expired license, that attendance at one regularly scheduled meeting of TREC. And given the discussions and your actions in your last month's activity, I felt compelled to put this on the agenda to see if you wanted to continue with this rule change or if you wanted to reconsider the rule of making this change in the future. And I'll just kind of remind you with the licenses in which people have been penalized. Some of your activities in the past were requiring them to come to TREC meetings, and since this was a similar practice, I just wanted to bring this back to your attention that under expireds, this is a requirement and a rule that went into effect in October, but I didn't know if you wanted to reconsider it.
So there's a definite distinction. One is a rule.
Right,
Well,
this is a rule.
It's a rule, and the other was just
A practice.
A practice. And so the question that Mr. Young and perhaps Office of Legal Counsel poses this commission today is, do you have any desire to change this particular rule to reflect the change in practice that we adopted we didn't adopt it, but put into effect last month? So the question is, I'll say it one more time before Sue gets me talk. Do you still want to keep people whose license expires, do you still want to require them to come to a TREC meeting? That's the question. Ms. Franks.
I think last month that we were pretty much in agreement that we have to give the same, I don't want to call it punishment, what's the word I need? Consideration. It all has to be the same to everybody. Now, and I live in Franklin, and it takes me about 45 minutes to get here. And we have a commissioner who comes 4 or 5 hours. And I think that it's for me, being from Franklin, it's easier for me to do that than it is for someone from Bristol or Memphis to come to have to do that. So I think the punishment is not equal. And I do believe that we should be doing the same thing and be consistent with what we do. So I would suggest that we figure out, is there a particular class? We've been doing, last month we started doing one regularly scheduled meeting of TREC or an 8-hour class. And we've been picking out what those classes are. I would love for us to be able to get consistent on what those classes are also. But with this before us at this moment, I would like to ask that we be able to give them CE credit in lieu of the scheduled meeting with TREC.
So, Ms. Kirby, Ms. Kirby, this would involve a rule change.
It would.
So
we would have to, I mean, we can't just override the rule that's in the books right now with that. Now, if we wanted to change it to that, we could start rulemaking next month. I could have something drafted for you to approve. But we would need to do it by rulemaking since it's specific in the rules right now.
So the question to commission, at least in my mind, is, I mean, not everybody lives in the same place. Right. So, but everybody has the same license. Right. And they're all subject to the same ordinances and rules. I don't know how we ever get everything. There's a difference between living in Hendersonville and Franklin, right? I mean, there's a difference. And I don't know. I mean, this goes away if people keep track of their license, right? We don't have to worry about it.
Right. But we had a gentleman last month that had to sleep in his car because he could not afford to get a hotel room. That is excessive in my mind to have to make someone pay for a hotel, pay for the gas, versus someone like me who can go home and sleep at my home. And I know, I don't want us to be starting, okay, Hendersonville is 5 miles farther than Franklin or that kind of thing. But I think we're doing it where they have a choice. They can either come to the meeting or they can take a class. And I know this is one that staff has been handling when this happens. So you would need to know what course do you want them to take. And I think it should be the specific course every time because it's the same reason and expired.
Commissioner Bloom.
John, last month I was not able to be at the meeting, so I listened for the very first time actually to the meeting on YouTube. And I would like to propose as at least something for us to think about, somebody who's disenfranchised by distance, let's say, that they sit in front of their computer and listen to the proceedings on YouTube. And we could have a staff member propose a 10, 15 questionnaire, send it to them by email, and all that could be same thing as attending a meeting.
Would you have to have different questions every month, though?
Yeah. Probably, because it'd be different every month. It'd be different.
Mr. McMullen.
I think the question I have is, why do we require this? Is it supposed to be punitive? Is it supposed to be beneficial? Is it supposed to help them to not make a mistake in the future? And I don't really think it ought to be punitive. I think it ought to be rehabilitative. I guess that's probably not the right word, but and so let's try to get people to think about this and to take it a little more seriously, maybe. And so I support offering either attendance at a meeting or some sort of continuing education class as an alternative for those people who just prefer to do that. I respect Commissioner Bloom's suggestion. I think that that's going to put more administrative burden on the staff to come up with questions. Although I think it's a good thought, it's difficult to police and enforce that. But I think to be consistent and to realize the purpose of what it's there for, it makes sense to me to offer in this situation of the expired license either class or come to the meeting. If we have to do a new rule to do that, I'm okay with that. But in principle, that's where I stand on it.
So we're trying to give direction to the law department today as much as anything as to whether we want her to proceed drafting a rule for us to discuss. But do we have latitude with civil penalties in this case? I mean, that's a universal. They could apply to every licensee.
There are no civil penalties with licensure
late
expiration, but there are late fees, yes.
Do we have latitude with late fees?
They're all in the rules, so you'd have to change the rules in order to change the late fees.
Late fee, if you're in Bristol, is the same as late fee as if you're in Memphis.
Yes.
I mean, that's universal. But today the question is, would you like for the law department to take a look at this particular rule and see if she can bring a proposed rule back for us to discuss? That'd be great.
Can I just throw out one other thought?
Yes.
So I would think that the goal of the commission would be that we want people with expired licenses to get them get that issue fixed as soon as possible, as soon as they realize it's expired. One thing I've just kind of thought about is that, and a licensee brought this to my attention, is that, if you realize your license is expired, let's say tomorrow, then you have to wait a whole nother month before you can even work again, because you have to attend a meeting. So that's just another thought to think about.
Also been possibly operating for a month without a license.
Right, but I'm just saying, if someone realizes they're in the wrong and they want to fix it, I feel like it's my opinion that they should have an option to be able to fix it as soon as possible and not have to wait until this commission meets again in order to right their wrong.
Well, and speaking to what Commissioner Bloom suggested, that would take care of that problem as well, because our previous month commission meeting would be on YouTube, and they could go ahead, if they discovered it tomorrow, and watch the last commission meeting.
Yeah,
the most recent commission meeting.
Or do a class or something.
Ms. Taylor.
The problem with that commission meeting, to me, is you have to have two people watch it. You have to have that person watch it and somebody that's going to write the questions to watch it and come up with the questions.
Well,
so
Could be somebody was here.
yeah, they would most likely be here. Brooke or Malcolm, he ain't got anything else to do.
Questions.
All right, let's not get too specific today. Is it the desire of this commission to revisit this particular rule? That's the question. Mr. Bloom.
Mr. Chairman, I think that rule ought to match what our activities and voice vote was last month.
So does that also carry on to like a formal hearing at that point? I mean, somebody from Bristol with a formal hearing is going to have a difficult situation compared to somebody from Franklin. I mean, I don't know where we draw that line.
You just...
What direction do you need now?
I guess I would need, if you would like to review some proposed rules next month, I'll need to kind of have an idea of what you want their options to be.
Personally, I'd like for you to let me know what maximum late fees could be.
Okay, I mean, the late fees can be whatever you want them to be. They're set out in the rules right now.
What are they now, about $50 a month for the first couple of months?
For the first, I think, up to 120 days. We have a chart somewhere. Up to 120 days, I think it's $50 a month, and then it goes up to $100 a month after that, and then after a year, they have to retest and reapply.
No matter where they live in the state.
Yes,
Right.
correct.
From my personal perspective, is there, if you can let us know if there's a limit on the late fees we can charge.
Okay, I'll look into it. I don't think there is, but I'll look into it to be sure.
Thanks. Other,
Commissioner?
yes.
A couple other options is to take this meeting around the state more often. So that's an option.
Mount Juliet's a nice place.
Mount Juliet is an awesome place right now. But a second option is there's nothing that says if we're going to say you have to watch a meeting on YouTube, nothing says it has to be the previous meeting. You could just designate a meeting, and like if we felt that December of 2015 was an awesome meeting, that could be the meeting. And so that way there's one set of questions.
That's a good idea.
And that's it.
So maybe once a quarter. That's a good idea.
My suggestion, if we go this direction, might be one that might have a hearing attached on it to it too. But that's just thought.
Yeah, I mean, that would require a little bit of work on the commission's part to, pick out those things that you wanted them to, whatever meeting it is you want to review periodically to decide that. So just keep that in mind. But
Okay, is that enough to get you started, Mallory? I know it's not very specific, but
well,
you bring us anything you want to, and we'll discuss it. How's that?
okay, maybe I'll bring you some options
Thank
and you
you.
can review
That'd
them
be
all.
Great. That's great.
We like options.
Okay.
All right, Mr. Floyd Love, are you here yet? All right, let's go to the second bullet under this topic, core topics for 2017 and 18. I don't know if that's Ross's or Malcolm's discussion topic.
Okay. Each year, what you do is you select the core topics for education. And if you will go to that part on your iPad, you will actually see the history of the core topics. What I'm doing is just wanting to start this discussion today. And when you come back next month in May, finalize those topics. That will be the core topics for the next education years, which will be 17 and 18.
Mr. Chairman, members of the commission, we want to do that to give the providers time to develop their courses for next year and the following year.
And we have a deadline of voting on that as June, don't we?
Haven't seen that, but in the past, it's been done in July.
Okay.
I'm just trying to move it up to give the providers additional time.
June's good.
But I wanted to give y'all some history today where you could start thinking about the actual courses or topics that you would want to require as core.
I think a few years ago we had a couple of instructors that developed commercial core courses so that we have a commercial core course as well as just a regular core course for residential. And as an instructor, I really, and Bobby also teaches the core class as well, there's already so much meat into it that trying to throw any commercial into the residential core course just muddies the water and gets everything off kilter. I really think we need to leave commercial out of the residential core course.
Well, what about property management? That's something we see a lot of problems with.
Well,
you're saying that's different though, commercial and property management?
Oh, yeah.
Okay. As long as we leave property management in.
Property management, I think probably, and Bobby, add your 2 cents worth into here, because I get a lot of questions on property management and stress the importance of having to have a license and go into that in more detail so that people realize you cannot just manage other people's property.
But are you saying there's a separate core for commercial?
Yes.
Okay.
One other word on that from me, Mr. Chairman, members of the commission. I analyzed the history, and I think what you're going to find is from way back until now, you've had TREC law rules and policy updates. That's been one that goes through the years. Agency courses, advertising courses, contracts courses, property management, including escrow, setup, and TREC requirements. And then I added ethics.
think all those are good. I think most people as brokers here, trainers, looking at other offers, I think that covers a lot of things that we see that aren't practiced very well.
I don't have a problem necessarily with ethics being added in there, but when you start adding stuff, you're gonna have to start taking stuff away. Because either that or we're gonna have to extend it to an 8-hour course, because it's hard to get everything in that we currently have to cover in 6 hours.
And ethics is already required.
Yeah, ethics is a required course by NAR.
Correct,
But not everybody is a realtor.
That's correct, and we have to tell folks a lot of times that though NAR requires it, TREC doesn't require it. But I only added that in as just for your information and going forward. You can come up with whatever, and I'd appreciate if you'd send me your suggestions as I develop this for next time, and I'll try to have you a set for residential.
Ms. Taylor.
I want to ask a question. Since you have a different course for commercial and residential, which I'm delighted you do, the same topics here are for both, but done in a different format for commercial, or are there different? This says residential core course topics.
Right. Well, as the discussion was, we've historically in the last several years we've had residential courses, core, and commercial core.
So this is, but okay. So they have different topics totally in
They
the.
may overlap some, but basically they're different.
Okay. I was thinking that maybe it might be a good idea if someone wanted extra credit that they could take, you know, the core course for commercial if you were a residential agent and did some, and vice versa. That's
I
what
don't
was
think
thinking.
anything prohibits that.
It happens.
Anybody
It
can take the
happens.
class.
Okay.
All right, this is really just to get it in front of you. You guys think about it. If you have suggestions, comments, email or call Ross, and we'll take it back up in May. All right, thanks. Let's go to this third bullet before we get to our next informal hearing. Since we've been on this topic, we have a request, and I'll defer to Malcolm again on this, for an individual who would like to get his real estate license from a distant part of the state who would like, well, let's just talk in general terms at this point. The discussion needs to be about that potential licensee showing up, but his or her potential broker appearing electronically or by Skype or by voice and not appearing in person. So we're trying to get a sense of what the commission thinks about that and whether or not we should take action in some form or fashion to allow that to occur. Ms. Hills.
Thinking about time, just like thinking about the hearing we had last month, it takes a while to get everybody up and going and on the other end, and that we can see them, and then it would be when we go somewhere else. If we travel to Jackson, will we have the same way of doing that? I'm just raising a question. I'm not speaking for or against. I'm just raising a question about that.
With technology changing the way it is, and I mean, you know, webinars are more common, Skyping, webcams, everybody's got them on their computers. But this is a state commission. We don't necessarily have all the equipment available to do the Skyping and everything, which would require equipment to be bought for Skype. So, I mean, I don't think we can make a decision to do Skype without that being approved through the state budget committee that equipment can be bought.
And I do feel that what's been amazing to me in my time here has been how many times there have been principal brokers that are sitting before us where we find out things about the principal broker. We've had one principal broker recently that in the middle of our questioning got up and said, I'm not going to have this person be my agent because they didn't tell me the truth. That's important. The other thing is we had one that said, well, I don't do the escrow. I don't do the escrow account. Sometimes the principal broker, our conversation with them, to me is as important as to that applicant's. I would like to see them be here so that we can talk to them where they don't have aides in their office sitting with them to say, don't say we don't do property management. We've had that. So I think it's better in this case that the principal broker be here to support that person or not.
Thank you, Ms. Franks. Other comments?
I would just like, if Malcolm, if you could just look at some point with the state IT person. I know they're busy doing some other things, but just see what kind of expense we would be incurring if we were to be able to do a Skype or some type of thing. I'm just curious. I like that idea. I want to be able to see them. I don't want to just talk to them. I want to be able to see them because I think I learn a lot by seeing them here. And so I would like to be able to see them. And if we could do that without a lot of money and maybe the state would help us with some money, I would like to think about that at least.
Basically, let me just kind of reiterate your statement here, is you would like for us to investigate the potential of being able to Skype individuals into the meetings where you could have a virtual interaction with the people that would be appearing before you.
And don't tie it to just Skype.
Video
It's
conferencing
whatever-
in general.
Yeah,
Right.
Thank you.
Okay.
I mean, that would also work and go back to people who don't live in the area attending the meetings. I mean, they could webcam it.
Like a webinar.
Well, we don't live stream this though, so they couldn't watch it live. It's just recorded and then posted to the website.
But could we live stream it?
I have no idea.
Is it expensive?
Yeah.
I think it's more.
I mean, they do it over at the General Assembly, but we don't do it here.
I guess in my mind, I draw a difference between somebody who is coming to sit in the audience and watch the meeting versus somebody who is here to speak to us and make a presentation to us or argue or answer questions or whatever. So I'm more comfortable, with in that situation, somebody watching it online or something. But I think if they're going to be here, if the applicant is here, I assume you're talking about like in an informal appearance situation like we just had. To me, it's just as important to have the principal broker here as it is to have the applicant here. And so if we're thinking about letting the principal broker video in, then you might as well be asking, well, should we let the applicant video in too? And I think it's important when they're here, we're judging their credibility, their ability to be a licensee in this business based on previous convictions, and I think it's important to have them here.
So the rule, just to clarify just a little bit maybe, the rule about this says any applicant for licensure appearing before the commission for the purpose of obtaining a license must also ensure the presence of his or her principal broker. So the question is your interpretation of presence of a principal broker, whether that's physical or whether that you would be open to interpreting that as video or otherwise. So that's kind of where we are. So we're not, just so we're clear, we're not granting any like exceptions or anything like that to the rule. It's basically how you all want to interpret your rule.
But you're saying that the applicant would always appear. It's just the broker. That's how
That you could interpret that differently if you wanted to as well. The question presented to us specifically was the principal broker only.
I would like to see the principal broker here. Do we need to take a vote on that so she'll know or what?
We'll talk about this.
Okay.
But we've got, our practice is consistent with the rule. And so the question I'll pose to members of the commission, do any of you wish to amend the practice that we've been following?
No.
If no one wants to amend that practice, and I see no reason to take a vote. Is that okay with members of the commission? All right. With that said, let me just tell the members of the audience one item. This commission and each of us individually are subject to the state's sunshine law, which says we can't discuss any business between ourselves outside of the public. So the discussion we just had, for instance, has not been discussed internally between 1, 2, 3, or 4 members of this commission in some closet somewhere. We're not allowed by law to do it. So sometimes you'll go, my gosh, they're taking a long time to talk about something. But it's really the first time we've been able to talk about that particular item. And so you'll bear with us, but that's the law. Now, with that said, I believe Floyd Love and Perry Hamlet have made it to the building. Is that correct? Gentlemen, will you come up, stand, let the law director swear you in, and then we'll get the process started. You can come up and have seats here, each in front of a microphone. And who is Mr. Love? Okay, sir.
You could both raise your right hand and repeat after me. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Very good.
All right, Mr. Young.
Okay. Okay, the applicant is Floyd Love. Love has passed the affiliate broker exam. The principal broker is Perry Hamlet. License number 253927, was first licensed as a broker in 9/26/2001 and became a principal broker of the firm in 10/16/2001. He is responsible for supervising 134 affiliate brokers and 15 brokers. There have been 0 complaints filed. The firm is the Realty Association, number 236927. And Mr. Love is before us today because of a felony due to vehicular homicide in which he was arrested in July 1980, convicted in December 1980, and was sentenced to 3 years probation without incident.
Thank you. All right, Mr. Love, you weren't here earlier, but you get the chance to tell us anything you want us to know about the incident, about you, about what you've been doing since the incident, if you just tell us what you'd like for us to know.
The incident occurred.
You'll need to speak clearly into the microphone. We're hard of hearing up here.
The incident occurred. I was riding a motorcycle with a passenger young lady on, and alcohol was involved. I was forced off the road into a curb and laid in a ditch all night long, and said the young lady was killed, and I stayed in the hospital about 15 days, but when I got out, I was arrested and charged with vehicular homicide, and for which I was given probation for 3 years, which I did, and without incident. Since that time, 95, I'm sorry, I gave my life to Christ and started working for the Lord, and I've been a deacon at my church ever since. And that's all I have to say about that.
Okay, Commissioner's questions for Mr. Love. Mr. Horn.
This was in 1995?
The accident happened in 1980.
1980, I see, okay. Makes a difference then. Have you finished all your fines? Are you straight with the state now in the criminal system?
Yes, sir.
I want to know.
Yes, Ms. Franks.
Mr. Love, how old were you in 1980?
1980, I was 28.
Mr. Love looks old or young.
I think he looked younger than that.
All right, if there are no other questions for Mr. Love, then Mr. Hamlet, if you will tell us a little bit about yourself, the company, and why you're interested in having Mr. Love as a licensee with you. Good luck on moving that mic.
They got them tied down pretty good there.
Can you hear me okay?
Can you just move toward Mr. Love just a little bit? Thank you.
Could you repeat the question?
Sure. I'd like to know a little bit about your company and why you have an interest in affiliating with Mr. Love.
Okay. Our company is a very much a service-minded organization to its licensees and to the public. I don't know if any of you ever met Henry Coffer, but Henry Coffer was the founder and owner, passed about 7 years ago, taught me that that my duty, Perry, is to protect the public, and I believe that I understand that. I believe I understand that very well. I'm not saying I'm perfect. Our company is staffed with, today while I'm sitting here, 2 brokers sitting at a desk in an office of their own, providing service to our licensees. In addition to that, we have probably 2 receptionists that are answering phones. I started my career at the Realty Association in the very beginning and was asked to be principal broker in 2001. In the first year, I met Floyd's wife, but I didn't know Floyd yet. And I admired his wife. She was a high performer. She knew how to do business, and I could call her my mentor. About 14 years ago, I kind of got to hearing Floyd's name mentioned around the office, and I get to see him every now and then. And, you know, sometimes you like people and sometimes you don't. I just happen to like him. And probably 3 years ago, he started talking about obtaining his real estate license, and I had no idea about his past. I would be here today if I did, I think, if the circumstances were different. But I've grown to know Floyd as a very much a gentleman, a leader of his family, and someone that I can admire as a father, and hopefully a grandfather one day. I believe in Floyd. I believe that Floyd made a mistake that cannot be changed, and I don't think that he would ever do that again. I do not think that he is a threat to the public. I think that he would be an asset to the public, and I would very much like to be his principal broker.
All right, questions for Mr. Hamlet? Is there a motion?
I'd like to make a motion. First, I'd like to say, Mr. Love, I can tell it's still very painful for you to have that conversation. And I recognize how hard that was for you to be here today. With that being said, I'd like to make a motion that we allow Mr. Love to move forward in his real estate career.
We have a motion by Mr. Chara, second by Mr. Wood. Is there discussion on the motion?
Can I just ask one question?
Sure.
Mr. Love, you retired from CSX in 2011. What have you been doing between 2011 and now?
I work at my church as a security officer from 1 o'clock to 6 in the afternoon. We run a academy, daycare, a school academy. Yes.
Mr. Love, you have the opportunity there to work for a very wise person, and that you ought to cherish that opportunity. So he's a very wise man.
He's got to pass his vote first, so.
That's right. That's right.
All right, is there other discussion? So if you're in favor of allowing Mr. Love to move forward and get his real estate license, you'll vote yes. If you're opposed, you'll vote no. All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Good luck, Mr. Love. We appreciate you coming in, and we wish you the best.
Thank you. God bless you.
God bless you.
So I'm gonna exercise the prerogative of the chair just for a second and go back to our previous conversation about whether a broker should be present. You know, I've read many of these applications where I've thought to myself, there's no way in the world I'm going to let that guy get a license in Tennessee until I see the relationship between the broker and the applicant's history. And sometimes, like we saw earlier today, the guy's wife is sitting back here, or the guy's mother is sitting back here. And I think all of that makes an impression that you just can't put your arms around
Right.
on a teleconference. Anyhow, let me ask, is Charles Hammer here?
Yes, he is.
Mr. Hammer, Ms. McHugh, if you two will come up, the law director will ask you to raise your right hand.
Me too.
Yes. Are you
Yes,
gonna, wait a minute, do you not plan to tell the truth? Okay, you too.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Have a seat, please. All right, Mr. Young.
Okay, applicant Charles Hammer. Mr. Hammer intends to apply for affiliate broker's license. His principal broker is Mary McHugh. License number 247116 was first licensed as a broker in 3/18/1991 and became principal broker of the firm on 4/14/1999. She is responsible for supervising 134 affiliate brokers and 15 brokers. There have been 0 complaints filed. Her firm name is Francis Ann Gwynn Realty, LLC, Rossville, Tennessee. For Mr. Hammer, the summary of disciplinary actions is a felony, which was possession of stolen property. He was arrested in October 1992, convicted in May of 1993, 3 years probation. Probation ended May 1996.
All right, thank you, Mr. Young. Mr. Hammer, at this time, you have the opportunity to tell us anything you'd like about the circumstances, the event, what you've been doing since then, anything you'd like for us to know.
Okay, the first thing is a correction. It was a misdemeanor, okay, not a felony. Okay, so I'm not sure where the felony was, but I was charged with the misdemeanor, receiving stolen property. Basically, it's a time frame in my life where if you look before that situation and then after that situation, there was nothing before. There's been nothing after. It was just something that I did. I was young. It was a roommate situation. I'm not justifying in any way, shape, or form. I've had to live with this, for a number of years now. Very sorry it happened. Basically, the circumstances were, it was a roommate situation. I lived there. I didn't have a lease. It was a gentleman's, handshake. We got in an argument over a girl. We sort of got in a altercation about it. He basically kicked me out, changed the locks. A lot of items that were there, and I did report this to the police, and there was nothing they could do about it. Furniture, a numismatic collection, and things that were left there that I was never able to recover that meant a lot to me. And so I basically did something that, like I said, I wish I would have never did. I got revenge. Isolated incident. I'm sorry it ever happened. I try not to even go there mentally anymore. And like I said, it was just an isolated incident. It was stupid. It was, I'm not going to sit here and make excuses for you. It was just.
All right, questions for Mr. Hammer?
I have a question.
Yes, Ms. Franks.
We have a copy here in the Court of Common Pleas of Lancaster County, Pennsylvania. And it says that you plead guilty to felony 3, felony of the 3rd degree, and misdemeanors of the 1st, 2nd, and 3rd degree. So that would be a felony, correct?
I have the paperwork from the court. It's nolli prost. In other words, the felony conviction was nolli prost. The burglary was nolli prost.
What is nolli prost?
That means they didn't have enough evidence to convict me. Nolli prost. The only thing on my record is a misdemeanor.
But you have signed here a guilty plea. I'm a little confused. I need my attorney's advice over here, Austin.
Which page are you looking at?
The very last 2 pages. Oh, no, let's see. Yeah, no. It's the one that's a copy.
Eleven of 16.
I have the docket here from the Court of
9 of 16.
right here with me. It even says it right here on this docket from the court that they're nolly pros. What you're referring to.
I just wanted to be sure.
Other questions for Mr. Hammer? Mr. Horn?
You have had no other priors.
Sir.
And have you looked at the possibility of expungement?
I have looked at that, yes, sir, I have. It's a long process, it's an expensive process. I might want to add that in my career, I've been a property manager, hotel general manager. I've run retirement communities. I've had the keys to many properties, to people's homes. I've been a insurance producer licensed by the state of Pennsylvania. I've never had one issue other than this isolated incident. I'm very proud of that. I live my life, certain set of principles, and I hold myself to a high standard. I'm in a lot of people's homes in my career, and things like that. A lot of confidence has been placed in me amongst the years with owners of companies, and I feel that I've tried and strived to live up to their expectations, and I feel I have.
Only thing that I have any vibes about whatsoever. It took you some time before you retaliated. So you have that tendency to get even sometimes?
No, sir. I mean, obviously, if you look after that, it's been 25 years. I mean, so it's been. No, it's just one of those things where I was young, I did something foolish, and I learned a lot from it. I mean, I learned from mistakes, and I think that's a key thing, to learn from your mistakes.
Happened up in Lancaster. What were you doing there? Were you living there, or?
Yeah, that's where I'm from
That's
originally.
where you're
Yes,
from.
sir.
Okay. And then you decided to get converted and come down to good old Tennessee.
Crossville, it's beautiful down here. Yeah.
Mr. McMullen?
Yeah, Mr. Hammer, you told us a little bit about the incident of the property owner throwing you out of the property. You tried to get belongings back. Police wouldn't help you. And then I think you said you wanted to get revenge, and so you committed this crime. But I've read through the paperwork and listened to what you said, but I don't really understand, how did this happen? What actually happened?
Well, like I said, we got in an argument. I was living with him. I didn't have any lease or anything like that, and I didn't get my driver's license. It was a short period of time. And basically, we got in over, it was stupid. It was over a girl. And then, I contacted the police, tried to get my stuff back, but legally they told me I didn't have any rights because I didn't have a lease. So I felt helpless. I mean, he had my stuff. He stole from me. And like I said, I'm not making excuses for it. If I could go back in time, I would obviously not do it.
So that's the part where I just want to know what happened. You said you talked to the police. They couldn't help you. What happened next?
I've talked to him. His name was Tony, called him Tony. And, I talked to him several times to try to, reason with him and stuff like that. And there was just no reason. And it just stuck with me. It stayed with me for some time. And I just had it in my head that, that I was basically going to get even somehow, some way, shape, or form. And like I said, it was stupid. I can't change it.
So you said you wanted to get even. What did you do to get even at that point?
Took money.
From him?
From him.
How did you do that?
Yeah, and into his garage.
You went into his garage and took
Correct.
money that
I
belonged
mean, it's
to
on
him.
the report. I mean, went into the garage, it took money from him, and stuff. And what you don't see on the report, now this is gonna sound ridiculous, I left money too.
How much money did you take?
I took, it was around $4,000, but I also left money.
Was it other stuff also?
No, just money.
Report I saw said something about $4,300 in quarters.
Correct.
So he had a lot of change, and you
Yes.
took all this change.
Correct. Right.
So, but you were convicted of receiving
Yeah.
stolen property. So
That's
had
correct.
he stolen it, or what? I don't understand that.
He had it in his garage. He collected it.
Okay.
And just so you know, the report's clear. I'm not the one who actually entered the premises.
Yes, that's what I was trying to understand. So,
Right.
just a second ago, you kind of made it sound like you went into the garage and
No.
took it, but somebody else did.
Somebody else did.
Okay, who was that?
And the guy's name was Danny Kling. It was somebody that I knew that went in and got it and stuff and brought the quarters to me. I knew they were stolen. I'm not going to sit here and lie to you. I mean, I knew they were stolen. I mean, I'm not, like I said, I'm not justifying it in any way. It was just a revenge factor. I wanted to sort of get even. It was, I knew they were stolen. I don't know what to do at that point. Like I said, it was just a foolish mistake. It was an isolated incident. And I just felt back in the day, I mean, I honestly, I can't even really tell you how I felt because I'm so far removed from that person. But I just know, thinking back about it, because I try to not go there. I just know it was just, I was mad, I was upset, I wanted revenge because he took a lot of valuable stuff. I mean, I'm not talking about he took a bad. I mean, I had, it was a numismatic collection that my father had given me. I had fly fishing equipment, some Ted Williams stuff that was given to me by my pop-up, priceless things that I could never get back. So, and I just felt like the police, I tried to do the right thing at first. I reported to the police. I tried to get him, to respond to me to no avail, because he was so angry at me. And so I just did something foolish.
How old were you at the time?
I was 20, it would have been 90, 81, 20, 27, 28, I think.
Mr. Bloom.
Yes, Mr. Hammer, did you just move to Crossville?
I just moved to Crossville. Settlement on our home was October 26th.
So you did your property management in Pennsylvania?
Pennsylvania and Delaware.
Were you licensed in Pennsylvania?
I was a licensed insurance producer in the state of Pennsylvania, yes, sir, after this incident.
Were you licensed in did you have a real estate license?
No, sir. I ran hotels and ran like manufactured housing developments and things like that.
Manage any property in Tennessee?
Excuse me?
Do you manage any property in Tennessee?
No, sir.
Okay, this won't affect my vote, but what are we going to do with 17,000 quarters?
No, how much space did that take up?
I didn't even.
It's heavy.
What did you do with the 4,300?
Well, took them to the bank.
And
it wasn't a well thought out thing.
You took them to the bank and deposited them?
You're correct.
Okay. Ms. McHugh, why don't you tell us why you're interested in Mr. Hammer affiliating with Quinn Real Estate?
Would you move that microphone to you, please?
Came to Fairfield Glade last fall and bought a home from one of my agents and got to know him a little bit, and then he came to talk to me and said he wanted to get his real estate license, and so we've had several conversations, and he goes to my church. I've seen him working since that time. I've watched his life and what he's done, and yeah, I'd like to have him on board.
Questions for Ms. McHugh? Yes, Ms. Franks.
How many agents do you have?
6.
6, okay.
Okay, is there a motion? The motion by Ms.
Second.
Taylor, seconded by Ms. Hills, is that Mr. Hammer be allowed to continue on with his desire to get a real estate license in Tennessee. Is there discussion on the motion? I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion carries unanimously. Ms. McHugh, on another topic, Frances Ann Quinn, she's a legend up there for a long time. Is she?
Mother.
I thought you kind of looked like that's what I was asking.
I didn't know her reputation went all the way this far, though, to Nashville.
You don't
He's
know
from
the
Knoxville.
chairman
He's from
either.
Knoxville.
Oh, you're from Knoxville.
But I used to work with Dick Scarborough, who had an office up in Crossville, yeah.
Started.
Yep. Anyhow, best of luck to both of you guys.
Thank
Thanks
you.
for coming
Thank
down.
you.
All right, let's go back to the commission discussion for just a second on absentee principal protocol. Do you all see that in your agenda? So I'm gonna just read you. I asked this to be put on the agenda, and it won't take long. And we don't have to do anything today. This is from a principal broker, an email to me, not a principal broker, an owner of a real estate company that has 5 offices. He says, the question I have is with respect to the responsibilities of the principal broker, and what procedures or paperwork can we have to back up or substitute for the principal broker when they are sick, out of town, or otherwise unreachable? I sent that email to Ms. Kirby, who sent me an email back, and that email says, neither the statutes or rules give anyone other than the principal broker the authority to do the things listed below. As far as the power of attorney goes, Office of Legal Counsel does not know if that would be sufficient to allow someone to act on behalf of the principal broker. In order to have an answer to that question, the parties wanting an answer would have to petition for a declaratory order from the Commission pursuant to TCA 4-5-223, unless the Commission decided to address it on their own. So I sent that back to the principal broker who sent me the question and said, Jim, legal counsel's opinion is pretty straightforward. And he sent me the final email in this series of emails and said, okay, thank you. At the end of the day, while it makes the realtor and or company appear inefficient, the public does not understand why they can't have their check, for instance, refund of earnest money or whatever, because of a principal broker being unavailable for a period of time. So I was intrigued by this declaratory order that Ms. Kirby referenced in her response to me. And I don't know what a declaratory order is and what authority we have to issue such.
Well, it's a part of the Administrative Procedures Act, and basically, I mean, I'm not super familiar with it because I haven't actually seen one happen before, but someone can petition the commission. I think you have to probably file it with the APD to be heard before the commission, and the commission would essentially like give a formal opinion on a question specific to that person that's asking.
Or the commission could institute it itself.
Yeah, I mean, if you all want to discuss it and come up with your decision on that, you can. But in terms of somebody else wanting an answer, it's like I get a lot of questions a lot that are like wanting me to basically tell them they can and can't do something. And unless I can just read them a statute that answers their question, that's what I tell them, that they can file this petition if they want a specific official opinion to their question. So that's what that is essentially.
The declaratory order is a decision that just affects one party, right? As opposed to like a rule that
Right.
affects everybody.
Right. My understanding is that exactly that petition would just be specific to that person. But I mean, you could rely on that to answer other questions of the same nature if the commission made a determination.
And I think in this conversation, maybe with Malcolm as well, the commission has the authority. Let's say a principal broker dies, then that owner of that firm can come to the commission and submit a plan on how they're going to handle the business until they get a new principal broker.
Right. We have a whole section in the rules that addresses that process.
That can happen. This broker's concern was, let's say one of his offices somebody wants to earn his money back, or one of the licensees wants to transfer to a new firm, or wants to retire his or her license, at this point, there's no way that can happen until that principal broker gets back into town or out of the hospital.
No, everybody scans and emails now.
And it doesn't matter, the principal broker can be over 50 miles away and be in a complete different state.
But I mean, if you're in Greece, you can scan and email, and you can phone. So
I'm not advocating. I just told them I'd put this topic up for discussion.
now I do see in the case, I had cancer some years back, and I knew I was going to be out for several months, and so I appointed another principal broker to take my place. If that's what they're talking about, if they're just talking about they're going on a vacation, going somewhere for a while, I have no trouble as a principal broker still being able to communicate with my agents no matter where I am.
Mr. Bloom?
Yeah, I think Ms. Kirby's right, and I think this broker's right. I don't know how we could have a broker Superman that's in 4 places at one time. So I think it's incumbent upon this commission to correct that.
Well, we do have some rules that address, like, for instance, if someone wants to switch firms, like we have specific TREC 1 rules that say if the principal broker is not available, you can like submit an affidavit of wanting to transfer firms. So like there are some specific instances where you don't necessarily have to have the principal. Now the way most people do it is they get the principal broker to sign the TREC 1 form, but we do have a provision that says if the principal broker is not available to do that, then you can do it this other way. In general, with what comes to mind specifically is like the escrow account situation. Our statutes and rules are specific about the principal broker being the only one with authority to do that. So I think that if the commission wanted to allow, an exception in certain situations, we'd probably have to do that via maybe rule, maybe even statute, but probably rule.
The example you've used, though, is that with the escrow account, so the principal broker could designate someone in that office to be able to sign the escrow checks, correct?
Yeah, but like I was saying, I don't think we can do that with the current state of our rules and statutes, because the statutes and rules say specifically the principal broker must do this.
I don't know how you live in Florida and
must deposit the money, must disperse any money. Yeah.
Any other comments on that topic? I sense I understand.
You do?
I'll be glad to pass it back to the broker that asked the question. All right, it's about 25 until 12, Nashville time. We'll reconvene at 5 minutes until 1 Nashville time. So please initial on the way out. Make sure you guys sign in, or initial when you come back in, and there'll be help to make sure you do it correctly. Thank you.
It's till 1 or after 1?
No, till 1.
And is Mr. Scarpness, is he on here?
He's on the agenda. We'll see.
We're supposed to have him at 10:45.
Okay. Yeah, we'll find out.
Yes.
Right, but the May is saying you
Uh,
can disperse it.
He can't do the informal hearing.
Okay.
Can't do that.
Good reason.
Well, he could still ask. He could come. He's on the agenda, so he could come.
Okay,
up.
you want him to come?
Well, it's up to him, but
Okay.
I think we've made our position clear. All right, Austin, are you?
I mean, accountant can write a check.
We're going to go to Sweats.
Hour and 20 minutes.
I tried to see if it was raining, it's not.
They got something for everybody there.
Alrighty.
That's her favorite thing there.
What?
But I think the principal broker still has to tell that.
It was the onion, it had nothing to do with the tomato.
Well, yeah, they still have to be over.
And I think that's
Well,
I think that's what Marcia did.
Right,
The
but I
Friday
think
news
the
at
Diane
Stony
question
River.
is, like, we just have
They put them on the
somebody
Caprice
who's-
Yeah, I mean, I think physically signing a check maybe, but
Giannini came in, did he
I
just
thought they were
look
asking
at
more
us?
like,
Oh, I didn't
if the
see.
principal
He came
broker's
in.
like out of the country, can somebody else?
I can carry
I don't think
2 more people in my car.
I'm gonna say
Stuck his head in the way.
Who's that?
Tim Lingerfeld from Kingsport.
I did it again. I'm gonna kill myself on that cold. That's the problem with most people
That's why I put mine.
Well, that's true.
Thank you, Jenica.
Watch your scored.
What time do we come back, John?
5
Sorry.
till 1.
Okay, thanks.
Don't be late.
I know. I know.
6 till 4 till 1. How about that?
We'll start without you. We'll be the same.
Oh, no, you probably need to straighten me out. I'm probably the mean one. But
All right. This is Mr. Scott.
thank you.
Oh, there was something. Where's the escrow part of this statute?
Oh, I don't know.
Yeah, I had Mark do.
Well, I mean, Laura read the whole thing.
Oh.
Those are all he had. The contractors is in.
All right, thank you.
Thank you very much.
Yeah.
Because they got. She essentially took over their directors.
Yeah, it was. A complaint was filed by another agent.
That's amazing.
Yeah.
That's a teeny little.
Yeah, we get that fairly often. I think it generally comes up when transactions don't go the way that
Someone
one of
gets
the
upset.
people. Yeah, maybe I should clarify what we were talking about.
All right, it's 5 to 1. We appreciate you being back on time. I think if we could go to the education report until we get legal back here to talk about these other topics. Is that all right with you, Mr. White?
Yes, sir, Mr. Chairman.
Thank
Members
you.
of the Commission.
Yeah.
The education agenda for April 6, 2016. Call your attention to that. I've reviewed courses and instructors and providers for all these presented to you. I submit to you numbers 1 through 24 are ready for your approval.
Motion to approve.
Second.
Okay, is this for the courses or the courses and instructors?
Courses.
Okay, the motion made by Mr. Chara and seconded by Ms. Hills is to approve courses A1 through A24 as presented by Mr. White. Is there discussion on the motion? All right, let's vote on the motion. Those in favor, vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Mr. Chairman, I abstain on A1.
Let the record so note.
Thank you.
Okay, what about instructors?
Yes, sir, Mr. Chairman, thank you. Continuing on with instructors who do need approval, they're marked as noted, and I'll present those to you also, 1 through 24 as noted, that need approval.
Motion to approve.
Motion by Commissioner Hill, seconded by Commissioner Taylor, that these instructors that need to be approved. Is there discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, Mr. White, what else on your report today?
Thank you, Mr. Chairman. I think just wanted to note that before you've got a listing to help you in your deliberations on consent orders. I think that each commissioner has a copy of that, and that was prepared to help you today as you go forward in the future months with potential courses to require those folks to attend.
That'd be a big help. Thank you. Questions for Mr. White or comments? All right, then let's move on to the agenda. Thank you, Mr. White. Ms. Franks asked that we add an item to the agenda related to principal broker education. And so I believe at this time it's an appropriate part of the agenda to take that up. So you have the floor, Ms. Franks.
Okay. When we started doing the education in lieu of time spent here at the TREC meetings, almost always there is a principal broker that is involved and needs to have some sort of education too. And in looking in these classes, I realized that there aren't really any principal broker courses. I talked to a couple of different instructors at the TAR meetings and about a course. I have one person had sent me something last night. It's just a draft, but it was basically a core class for principal brokers. Now, I'm not advocating that we make this a mandatory, every principal broker has to take this core class yet, but as we are doing the hours for the principal brokers and we're having to pick out what fits, the problem, I think it would behoove us to look further into some education for principal brokers. We seem to have a really a problem. If there's a problem with an affiliate or a broker, there's a problem with a principal broker. So I would just wanted to throw that out there to the commission to find out what you would think about some of the different educators coming up with courses that had to do with a core class for principal brokers. I have a list of things that might include, and they're similar to what we have for the regular core class, but more slanted towards being a manager of a real estate firm. So I'm not making a motion of any type, but I would just like to put that out there, and maybe we could have some discussion
now or next month or whenever you think was?
Well, as an instructor, I can respond probably to why that kind of has gotten put on the back burner for most instructors. It's very time consuming to write a course. It takes a very long time to write a course. And when you're talking about only a course that only principal brokers are going to be taking, like in my area, you would be talking about 30 principal brokers. So to spend 80 hours writing a 6-hour course for 30 people to take, it's just not financially beneficial to them. Now, we did have several years ago a couple of instructors that were going to write broker core courses and just quit. Never did, because, you know, we would be all for that. But speaking from the instructor side, I'm sure that's why nobody has done that, is that it's very time consuming and, you know, it's not a lot of profit in it.
Well,
for 'em.
and the one that I have is just a draft, and it's just an outline. But you know, if we don't have people interested in doing it statewide, then maybe there's a possibility of having it an online class.
CE Workshop would probably be a good source to talk to about maybe doing something like that. That's who Susan Barnett and I wrote the core course for. And they're very diligent in their research and making sure they have facts together pretty good. So they might be a good one. But online may be the best course to pursue that.
Other commissioners? I think the concept is good if that can be developed.
Well, I have one person who's wanting to develop it.
That'd be good.
Okay. I didn't know whether to encourage or discourage, so I guess
Encourage.
Okay.
Okay. Other comments or questions related to education? If not, I think I know this answer, but is Kevin Sharpness here? Last call for Johnny McBowen. Are you here? All right. But that's handled, and Mr. Young, you have a report for us today.
I do have a report. Thank you very much. In fact, I've been criticized that my reports have been too brief, so maybe I need to expand it
Who said
today.
that?
Actually, there are a couple of things, just housekeeping, I want to touch on real quickly before I get into my report. First thing that is posted in your iPads is when Stay Alfred came before you 2 months ago, one of the requirements of your motion was to submit their financials or what their receipts were as far as deposits. Just as a courtesy to the commission, I did load that up in the iPad, but this is something that Mallory and I are monitoring on a monthly basis, and then on a quarterly basis, we will come back to you with an update. The other thing I also wanted to point out is we had Rice come before you this past month with a very good report. They did follow up with an additional report this past month that I also put in your packet. I think that this will be a very helpful tool as we look at core education courses for 17 and 18 as far as materials. So I wanted to also point out that that would be something useful. Now, getting to the my report just real quickly, I will tell you that on the core, which is not core courses, but our online platform, we're moving very good with this. We are now in a test phase for feeds with errors and omissions. We've completed redoing the TREC 1 form. Also, with the application, we have completely revised that for online purposes as well. So I will tell you that we're moving in a timely fashion with that. With a June the 22nd deadline on that. Ross did a very good job in going over the education area. As far as communications, we're working on updating the website. And after the last meeting, we distributed the TREC newsletter, and we will also be working on other areas. As far as customer service, we have a staff training session with the attorneys, customer service, and the TREC staff on April the 20th. We're actually bringing in a real estate instructor to go over rules, regs, laws. I think many of you know that we have a number of brand new staff people, including myself, that will benefit from this. We had a very successful commissioner update with the majority of the commissioners present at the Tennessee Association of Realtors meeting with an update, which we got very, very good reviews. I've continued to accept other invitations as far as commission director outreaches to let people know what we're also doing. In the January financials, the total expenditures for February for TREC was $75,819, combined with the payroll of $56,031, and cumulative expenses for the year was $649,000 plus cost backs of $419,000. I've also included several
What do you mean by cost back plus cost backs?
It's basically those are those are like the customer service center and things of that nature. All the joint activities that are part of the commerce and insurance group that kind of combines it. Then I've included the statistical information on the next pages as far as the total licensees, and those are also for your reference as well. And anyway, that concludes my report. I think we've covered a lot of the other items in my report of some of the prior things that y'all have done. Any other questions?
Ms. Hills, Mr. Bloom, second.
Yes, Malcolm. Oh, I'm
Yes,
sorry.
sir.
Go ahead. Malcolm, I was listening last month to the report, and Brian mentioned the number of days it took to process an applicant had greatly shrunk. But could you repeat that for me so I could write that down?
Yes, it's 15 days.
And it was?
I think it was around 20 to 25.
Great, thank you.
And I will tell you, Gary, as a follow-up, there was a backlog, and we're totally caught up at this point.
Great.
Newsletter, great job. Thank
you.
you. Great job. Two things. One, I had a call Monday, Tuesday from a broker and said that she had two agents renewed their license. One was renewed in February. They still haven't received the new license, and one was in March. And I don't know names, dates, or anything. Is that something? The March, it could have been at the end of March. She didn't tell me. But the February made me wonder.
If I could get the names of,
Okay.
of those agents, I will take care of that. But also, Diane, let me address that. One of the things that we're exploring is the actual paper license that is issued. That's a third party that's out of our department. That I'm very happy to say that we're exploring being able to when we go online, that the agent will actually be able to hit a button, and they will be able to download and print their license, which I think will really help the situation.
I assured her as long as it showed up that she was renewed, they were renewed. She was fine.
As long as it shows online that they're renewed, they're good to go.
Okay. And one other thing. So on our site, our new site, will there be a time that I can look up an agent and know what company they're licensed with?
Yes.
Okay. Thank you.
You're welcome.
Questions for Mr. Young? So I'll just mention two things. First of all, I got a letter from you last week, courtesy letter reminding me my license was set to expire in August of this year.
Probably said you needed education
And
too.
it did,
Your
which
grandfather.
I just want to let you know I don't. Okay.
Thank you for not being one of those 600 callers last week.
Well, I just want to mention that.
But we took that grandfather-in-law away and you just didn't know it. We snuck that
So,
in
so
on
what's
you.
the plan to let the people, the 600, know that got the letter?
We've actually, in fact, the letter dropped yesterday. It was mailed yesterday. That it explained that they received that letter in error.
Okay, great.
Second of all, I appreciate the detail in the financials, but there's one section that I don't think you need to include, and that's specific line items for employee salary. I don't think we need that. I don't think we've ever gotten it.
Okay.
But it's here today, and so.
And to compliment the AEs, when you spoke, I've heard nothing but praises. Thank you.
I think it's because I gave them my cell phone number.
Maybe so.
All right.
Thank you.
Thank you, Mr. Young. All right, Ms. Kirby, let's talk.
Are we going to talk about Arello?
Anytime.
Is that,
Let's do
is
it
that
now.
under his?
Let's
I
do
thought
it.
it would be under his.
Talk about it. Go.
Well, I guess what I'm wondering is the meeting in September is in Vancouver, and I'm planning on going. I know that the state doesn't pay for us to go out of the country. I'm just wondering, will the state pay for me to get to Seattle?
I think that would be, let me start exploring that.
I could take a train from there.
Because I think there would be several of us
Okay.
that may be a question back. And I will tell you, when we were talking about the original Rello request for next week, it was not out of the question as far as Vancouver. Hawaii next year is more than likely out of the question, but the Vancouver agenda item, I think that could be more feasible for them to consider.
I'm on the programs committee, and that's who decides where we go. And so next week when we meet, I'll tell them that it may not just be Tennessee that has a problem with that we need to look into that.
Okay, thank you.
That's all.
Okay.
South Africa will have a real problem.
So we're on the legal report, and in particular, rulemaking. Do you have some documents you'd like for us to approve?
I do have some documents. So last month, you all approved some rules that I drafted about the online submission process, and you also approved the regulatory flexibility analysis that went with that. There are a few other things that go with it, the rulemaking process, that have to get submitted to different places at different points along the way. Sometimes like when you actually have a rulemaking hearing, some of this takes place during that hearing, and then it gets submitted afterwards, but we're trying to do these without a hearing. So that's why I'm giving it to you now. So I've given you the economic impact statement memo, and these are all that's required for us to do by statute. And I've basically answered all of the questions in there, and if you have any revisions that you would like to make to them or don't agree with something I've written, just let me know and we can make any revisions. I know on number 1, the question that says the type or types of small business and an end of identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. There was a suggestion I had just included in my draft about 4,300 because that's the number of firms, real estate firms, timeshare registrations, and vacation lodging service firms that we have. It was also suggested to perhaps include individuals as well, since they're independent contractors and non-employees of the firm. So if you all would like to change it to that number, which would be approximately 38,000, we can do that as well.
I think that sounds good.
Okay.
So do you want us to approve these one at a time?
You can, either way, you can do them all 3 separately or one at a time. I can explain each one individually if you'd like.
We're on the economic impact study.
Yes, it says, that's the one that says Subject Regulatory Flexibility Act, and then underneath that it says Economic Impact Statement and Impact on Local Governments and the subject matter on the front page.
Towards the bottom of the iPad.
Let's see, how does it show up on your iPad?
20.
Yep. These questions basically ask us to think about how this rule change affects local small businesses. And really this rule doesn't do much other than help small businesses get things done quicker when they're transacting business with the commission. If we are to implement this kind
So that's
of
why that
program.
number needs to be larger, if we can have a larger number than 4,300.
Yeah, we can, I mean, I don't.
Do you know what that number is?
About 38,000.
Okay.
Yeah.
Oh, yeah.
4,300 is exactly the number of dollars and quarters that guy stole.
Can't get over those quarters. All right, so we need a motion?
Yeah, for the audience's benefit, these were emailed to us with Ms. Kirby's recommendations. Hopefully everybody had a chance to look at them. It's pretty much perfunctory type of work we're doing here. There's not anything controversial that I see. So if there's a commissioner in the mood to make a motion to approve the economic impact study, it's appropriate time to do it.
I'd like to make a motion.
Economic impact statement, excuse me.
I'd like to make a motion that we approve the economic impact statement with the one exception of changing the number in line 1 to 38,000.
I've got a motion by Ms. Frank, seconded by Commissioner Horn, that this economic impact statement as submitted by Ms. Kirby with one exception be approved. Is there discussion? All right, let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no. The motion passes unanimously. What's the next document?
The next document is, I think maybe they were combined on the iPads into one document, but there are some questions that the Joint Government Operations Committee over at the General Assembly asks us to consider when submitting rules, because any rules that are proposed have to go through that committee. So you'll see those. Those are labeled A through G, I believe.
Number 19.
A through I, I'm sorry. And yeah, those are just the standard questions that all rules have to take into consideration from that committee. The other document that I think is attached on the same thing on your iPad is the questions from the governor's office. And those are just questions that our governor has asked of all of the agencies that are making rules to consider.
Okay, so if you'd like, take a minute and look at the proposed answers to those questions.
Pretty straightforward for this rule, for these rules.
Motion to accept.
Second.
Motion by Ms. Hill, seconded by Ms. Franks, that the answers proposed are acceptable to commission and should be submitted. Is there discussion on that motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Okay, and that should be all of the documents that I need y'all to review. They'll get submitted. They have to be approved up through the chain of command here in our department. Then they go to the governor's office. Then they go to Secretary of State to be filed. So that's where we are with that. While I have it in my mind about going back to the principal broker, acting on behalf of the principal broker, because Jenica and I were kind of talking about it after we took our break, and I don't know, she seemed to have thought of the question differently than I had, so I just wanted to make sure we were all on the same page. There isn't really anything in the rule specifically that says like the principal broker has to be the one that necessarily physically signs the checks. I was thinking it more of who gets to make the decision of whether a check needs to be made. So that's kind of what I was thinking. I didn't know if that's what y'all were asking or if I was misinterpreting the question. But my understanding of the rules is that the principal broker makes the decisions on those types of things, but they don't necessarily have to be the one that actually puts the pen on the check and writes it.
Well, that was kind of how it sounded, and I'm like,
Okay.
They need to be the person who directs. If you have a co-signer on the account, they need to be the person who directs that. I mean, I would never have somebody just take care of the escrow
Right.
account
Like
without my knowledge.
Like I don't think a principal broker can leave the country and say, "Hey, you other broker, you can decide whether this escrow money needs to be dispersed." But if that principal broker okays that, the check can be written, I think. So there's that.
Thank you for.
Okay, so we're about to get into the section of our meeting where people have filed complaints against other real estate agents or against themselves, maybe. I don't know. I don't think so. Those complaints are handled by the law department, who collects that information both from the complainant and the respondent, and at some point condenses it into a narrative. And so you're going to hear Ms. Kirby read several different cases, and at the end of each one, she'll make a recommendation on what she thinks this commission should do. The commission has every right to accept her recommendation, modify or reject her recommendation, or reject it outright. And so you'll hear discussion on these topics as we go through. But to make sure you understand, we have no idea who these complaints are about, what company, what part of the state, what sex the respondent is, or what sex the complainant is. It's supposed to be anonymous, and that's how we're trying to treat it. All right, Ms. Kirby, you ready?
Yeah, the first thing I have is actually, it's a separate document on your legal report. I'm going to ask Dennis Gregory to come up. Did he just step out? Okay. He's one of our litigators. He's been with us, how long? 6 months or so? About 6 months or so. And he has a case that he's working on that he wanted to bring to the commission to consider a few different things. So I'll have him come up. The document on your iPads is number 24. I made it a separate document because this particular case had a whole bunch of respondents, and instead of adding on 15 pages to my legal report, I just put it in a separate document for y'all.
What's it called?
It's called Dennis Litigation Represent, number 24.
Well, mine's.
Oh, it's different numbers?
Well, they're moving to the top once I open them, so.
Oh, okay.
Wait a minute. Okay. Out of here.
All right, Dennis.
Anywhere up there's
We're
fine.
good.
What's it
Have a
called?
seat, Dennis.
What'd
That's
you say?
perfect. Unless you prefer to stand.
Sitting's good. I'm accustomed to sitting in most of these matters. No, as Mallory was saying, it's previously come before the body some time ago, and I'd probably just be easy for me just to, if you all have got the same, you got the litigator's case review, and then it goes into factual analysis. If you all got all that in front of you, so we can just kind of follow along. I'll kind of just get summarize. Well, this is my summary, so I'll just kind of read it verbatim, and then kind of go into some of my thoughts, given the case since it was last before the body. Factual analysis: home builder in the state constructed subject homes in both Tennessee and Kentucky. Primary complaints are with the builder. Now, that's really going to be sort of what the genesis of this represent is about, is that if the matter were heard at a formal hearing, and it may very well be ultimately, I think what you're going to hear from the complainants are primarily directed at the builder versus the real estate agent. So back to the analysis. The builder went into Chapter 7, protection. Builder no longer serviced the one-year home warranty. And then given the structural problems identified by the complainants, there was little to no remedy short of hiring substitute contractors to fix the issue. So we have several, and rightfully so, disgruntled new homeowners that had to find other contractors to fix the problems. Most of the problems have been dealing with water seepage, basements that had water in them. One of the complainants had a yard that I think wasn't really properly landscaped. But in any event, a number of problems. Respondent 1, as I sort of, this is the best way that I could characterize it, kind of became the face of the builder. As the builder began to wind up its operations as a general contractor, they were absent more and more. When phone calls were made to the builder, sort of radio silence from that point on. So the agent kind of became the point of contact. Turns out as well, the agent's also married to the proprietor of the builder. And that may be where sort of the rubber hits the road in terms of what did the agent know at the time that the builder was going into receivership, into liquidation. Because I think what the complaint had underlied before was that the respondent one, the agent, attempted to sell these homes off before the bankruptcy was in effect. So, in other words, they sped up the process of selling, punch lists that weren't completely done to the letter, and then the problems arose. But again, all the problems that, as far as I can see, once the case file has been with me, has all dealt again with structural issues versus really issues that related to the sale or the events leading up to the sale. Some new information that I've come in actually within the last couple of weeks. One of the complainants has even engaged respondent number one to hire her or hire the individual for another sale. So this is not a situation where the complainants have completely washed their hands of at least one of at least the respondent number one, but rather has attempted to engage them again. So that kind of begs the question as to, one, how deep does the cut go, and then two, are even the consumers willing to sort of look at this as maybe this was a builder issue, not so much a real estate agent issue. Most of the complaints did not arise until after the business went into Chapter 7. So again, these are not issues that arose at the inception of the contracts, the sale contracts. They were issues that arose again after the corporation went into Chapter 7. So, why am I here? I guess to make this or a couple of pitches. One, there should be some kind of discipline. I don't think we can get around that. And if the respondents were here today, they likely would say that not everything went as it should have. I think that, and this is just kind of based on my limited interaction with Respondents Counsel. They have retained counsel since the notice of hearing and charges were filed. And by the way, currently this is set to be heard June 3rd. So this would be the June meeting for the body. I believe that if the current 180-day, not revocation rather, but suspension were either reduced to say half or potentially eliminated, the case would likely settle. But again, that is just based on my own supposition. And I can only use my experience and sort of share that with you. Prior to the hearing, there would likely need, and prior to getting to a formal hearing, not even saying that this would happen June 3rd, but likely we would do a number of depositions, which is it's not outside the realm of any other case, whether before this board or any other. But I would anticipate the June 3rd date being pushed to the right, and so we may be taking this up later once those depositions, once that discovery is out of the way. So 6 complainants, I would say most likely in terms of a formal hearing, it would take most of the day if we were to hear them. Assuming that each complainant did appear before the board either in person or telephonically. I doubt affidavits would be part of the equation, since those would be inadmissible if the opposing party objected to them. In terms of respondent number 2, which would be the principal broker in this matter, I expected that you would hear very little from that individual in terms of their knowledge about any of these complaints. In fact, based on my own investigation, that individual would say he only was aware of one. Now, that may be the wrong answer altogether, that the principal broker only was aware of one of these instances. You know, there's also school of thought that he or she should have been aware of all of these. So I understand that may be a concern in and of itself for the board. But again, this was my opportunity to sort of pitch this as a maybe a means of resolving this without the need for a formal hearing. Certainly, from my perspective, that's what I'm employed to do. So it's not any issue to take this to formal hearing at some point in the future. But did want to put the issue on the table again for the board's consideration. And if anybody has any questions, I may or may not be able to answer them, but I'll give you my best.
I'm wondering, so you said that the complainant is going to hire respondent 1 again for another transaction. Is it with the same builder, her husband?
To fill in some more gray area, the builder is out of business. In fact, the builder has been disciplined by another board in this agency. So they are no longer, unless of course, and I don't know this, that maybe she has opened up the business in another under some other title. Don't know that, but there has been discipline with the builder.
And if they had, the principal broker said they had little knowledge, aware of only one. Did the principal broker have the paperwork?
On all 6?
Mm-hmm.
I do not know. Based on my recollection, yes, but I'm not sure that the principal was, again, maybe as engaged as in a perfect world should have been.
So you're saying what the problem was structural issues and water under the house?
Yes.
Okay. Did they close on the properties?
Yes.
Did they close knowing there were structural issues and water under the house?
Likely not water under the house, but they knew that there were items that they addressed on the punch list that were not remedied. And in all, I've got to lay it all out. The respondent number 1, the realtor, knew about some of these issues, and I think that there probably was, I don't want to say promises, but there were likely statements made by the realtor to lead the folks to believe those problems would be remedied by the builder. Obviously not remedied by the agent themselves, because to my knowledge that person has no technical contractor knowledge where they could have fixed it themselves. It would have had to have been through the builder.
Did they know there was the structural problem before they closed?
The buyer?
The buyers?
No.
But you're sure that the builder did?
Based on the discipline that was handed down, they've essentially consented to that.
Taylor.
I don't see how we can make a decision on this without really hearing this. I mean, it's just, I hear what you say, but for me to make a decision on that, I'd have to read over this very carefully and get a better understanding of. It's hard to say when you say he or she or respondent number 1 and respondent number 2. I just don't feel like I can make a decision myself.
We've already heard it though, right?
Yeah, we
heard
that we proposed a 180-day suspension, a $6,000 civil penalty, attendance at a meeting to respondent number 1, who was the affiliate, correct?
Yes,
and we
that's
proposed a $6,000 civil penalty, 30-hour office broker management course, and attendance at a hearing to respondent number 2, who was the principal broker, correct?
Correct.
So, and as I understand it, it sounds like the affiliate probably knew what was about to happen to the broker, or excuse me, the affiliate probably knew what was about to happen to the building company, because that was the building company, the contractor was owned by the affiliate's spouse. And they rushed transactions to close before the bankruptcy was filed, knowing that punch list items were not going to be completed before the bankruptcy was filed, but they were just rushing to get those things sold before they filed bankruptcy.
And that's going to be sort of the proverbial question of fact, that kind of like what you're saying, we only would know that before a hearing.
You'd have to prove it.
Right. And it could be difficult, to prove that spouse realtor knew the financial health of spouse builder company. I don't know enough about the ins and outs of their personal relationship to know whether or not that they were sharing information. But
you're saying that we proposed this as the potential agreement that they could have with us to resolve this.
Right.
And you're coming to us, and you would be litigating the case if it does go forward to litigation?
Yes.
And so you're saying that they may be willing to accept an agreement if the suspension of respondent number one were lowered from 180 days to 90 days.
Yes.
And when I was mentioning the penalty a minute ago, I left out part that said that, well, let's see, it was respondent number one has a principal broker's license. I think, well, it said respondent one's license will be downgraded to an affiliate broker's license, and respondent one will not be permitted to test again to be a broker for 1 year from the date of the downgrade. So are they still willing to do that? They don't want that. They're not asking for that to be changed?
No.
So
it's just, I think the long pole in the tent, so to speak, is the length of the suspension.
Do you have a recommendation for us? Do you recommend that we reduce it, or?
That's my recommendation, to either eliminate or reduce the voluntary suspension.
You think, I mean, you've been working, I guess, to get it ready. I mean, how do you feel about the case?
The real question's going to be, was respondent one, the realtor spouse, making promises to these buyers, knowing at the time that spouse's business was about to close up shop, and were they just simply trying to get rid of the properties to maximize profit and sort of hold on for the tumble?
You said that there's already been some sort of discipline against the spouse through the contractors board or whatever.
Right.
And was that based on the spouse knowing, well, I mean, similar allegations, but just with respect to the spouse?
Just with respect to just the spouse, just to, getting into workmanship issues that, just shoddy workmanship, really. That's just the best way to put it. That the homes, given the fact that the problems related to water seepage and landscaping, I mean, with people's yards filling up with water, clearly there was some drainage problem that might not have been, house might have been perfectly sealed in some cases, but the yards were holding water. It all relates to maybe not his personal workmanship, because it was a large enough business where there were a number of folks employed by them.
So if it went forward to a formal hearing, could we revoke the license based on what may be proven?
Revoke both the affiliate and the.
Sure. Yeah.
Do whatever you want, formal hearing.
Okay.
I mean, if it's within the statutory things that you can do, which it is. I mean, you can revoke, suspend.
I just wanted to make sure I understood that what we were offering to them was not as bad as it could get.
Bad as it could be.
Yeah.
Right.
If they go to a formal hearing.
Right.
I don't know if they understand that.
Their counsel, I think, knows that, but I hope.
I just want to make sure. So the builder is not a real estate agent.
Correct.
Okay. But respondent one has to be married to the builder.
That's right.
Okay. Here is maybe a potential flaw. I'm gonna call with I'm gonna say the buyer side. Even though, I mean, they knew there was issues wrong, And even though they were promised they're going to be fixed, they still accepted it by buying the property. And at closing, they have to sign a document that says you accept the property as is. And that could be not finished painting, no carpet, but they bought it. And they trusted somebody, and they didn't fulfill that obligation. That's where I'm thinking we might want to consider negotiating.
Well, in that final walkthrough they did, though, they could have accepted the property with exceptions, too, that those repairs would be done.
I don't think the closing statement says you accept it with exceptions.
Yes,
I think it says
it does.
You can escrow it. You
Yeah,
can
you
escrow
can
it.
write it in that
But apparently they
repairs
didn't
need to
escrow
be
it.
done.
I mean, they made a bad business decision.
Yes.
By trusting the person.
I think you're right.
Yeah.
Well, and were those things written? Was there? You said that the agent was telling them that her husband would take care of them. Did she write that down?
No, this was all just word of mouth.
Conversation, so it's
Correct.
not provable.
Yeah, it's hearsay. Correct.
So, Mr. Gregory, how many attorneys could be present if we had a formal hearing?
It would just be myself and the respondents' counsel, so just two.
The complainants won't show up?
I would anticipate the complainants would show up. Because of the nature of some of the complainants' professions, they may or may not be available in person. Some would likely ask to participate telephonically. But no, I would anticipate it would be most of the complainants live. You'd have an actual person to.
I've not had you litigate a case in front of this commission. Are you a guy that goes on forever? I mean, why do you think it's going to take all day with just two attorneys?
Because you got 6 complainants.
That's pretty much it, because of the number of complainants. No, to answer the question, I tend to not be too long.
Well, and it's 12 different complaints. So when you go to like make your findings of fact, conclusions of law, and your disciplinary action, you have to do it. You're gonna have to do it separately for each complaint because it's 12 different matters, right, Dennis?
All day.
Right.
Yeah.
Right.
That's no problem.
Okay, so.
As long as Alton's here.
So, and what if he's not, is what I'm
Yeah,
thinking.
he'd have to be.
So you used
He's gonna be
a
sick
legal
that day.
term that I'd not heard before called I think you called it the long pole in the tent.
That's just kind of a.
What does that mean?
That is
It's a Black's Law Dictionary term.
Coming from a military background, that was like when you put the tent up. That's the long one that sometimes is the hardest one to put up. That.
And proven intent is going to be the long pole. Is that it?
Right.
Okay.
Right.
Because we hold the brokers responsible for knowing everything the licensees do, whether they know it or not. We do hold it. But you know, proving that the wife knew or did not know is.
But she's the broker.
No, respondent one.
Licensee, correct?
Is the licensee.
She's
Correct.
licensee.
She's the. In this,
Which respondent is she, 1 or 2?
respondent number 1.
And the brokers too, correct?
Correct.
Mm-hmm. So, I mean,
They both have broker's license. She's a broker.
okay, she is, and
What's a
the
baby?
reduced
Two's
her.
a principal broker.
Okay.
And sort of, and this may have no bearing at all. To my knowledge, none of the respondents have complainants, have taken this up individually as a civil matter. I mean, you know, what comes to mind is some kind of, civil action against against the builder, against everybody. That has never happened.
But they would come here first before they did that, so that they could say.
Not necessarily, but it would strengthen their case,
Right.
certainly. Right.
Yes, Mr. Bloom.
Yes, sir. Let me see if I get this right. All the 6 complainants will be here if we have a hearing?
Couldn't guarantee that,
okay.
but I think the majority would be here.
All right, let's say we do not, because we cut the discipline from 180 to 90, does all that go away, and do these 6 complainants not get their day in court?
If they agree to, via consent order, I mean, I'm sure it would probably take well, I'm not sure if the board would have to look at because it would be a new consent order. I mean, it'd be without the full 180-day suspension or with a reduced suspension. But to answer your question, no, they would not get their day in this court. I mean, they certainly would still be able to bring any kind of civil action that's still within the statute of limitations. I mean, you have to keep in mind this was in 2013 and 2014, so the time's running on that. It's not out. I mean, the statute of limitations for most contract matters is 6 years. They've already lost some of their consumer protection claims. That runs after a year, but a year from the substantial completion of the structure. But all of them would still
When did Respondent 1's 180 days start?
Time of the.
Well, it hasn't because they didn't.
they
didn't accept the consent order, so it would only.
Correct.
It would only start when they accepted.
So they're still out
whatever
there
it is.
doing real estate.
Exactly.
Mhm.
There's no summary suspension, nothing like that. Right.
Remember too, our hearings or your hearings, the complainant is not a party, so it's between TREC and the respondent. So if the complainant wants their day in court, like, they need to go to civil court. So y'all need to decide whether it's in the best interest of the public for you to litigate or to go ahead and agree to a different consent order.
I personally would like to leave it the way it is. I mean, we went through this, obviously spent a lot of time on it, and for good reason, we came up with this conclusion. I don't think that there's been anything presented to us that warrants reducing the length of time that we downgrade the license, and Respondent 1 will not be permitted to test again to be a broker for 1 year from the date of downgrade. So they're wanting to be a principal, they're wanting to be a broker again, but they're not the principal broker, right?
Correct.
For instance, Ms. Franks, you could modify any recommendation and say, reduce the suspension from 180 to 90, but increase the length of time before they become the principal broker again, or get their broker's license from 1 year to 2 years, if that's the issue.
But it doesn't change their way of doing business to make them a broker or an affiliate broker. There's not that much difference if you're not a principal broker.
I think this broker was a lot more involved and knew a lot more.
Respondent 2?
No, the wife.
Oh, that broker, okay.
And there's really no way of knowing that until we get them in here and let them testify. If she can prove that listen, my husband's a builder and developer, and I don't know everything he does. He doesn't want me to know everything he does.
You probably know if he's going bankrupt.
Maybe, but maybe not. So I think the thing that it would behoove them to come in here and plead their case.
Ms. Taylor.
That's what I was going to do. Is it appropriate to make a motion to?
Let's look at it this way. If no motion is made, then what have we done in the past stands.
I got you.
On the other hand, if someone wants to make a motion based on conversation with state's attorney, that's perfectly appropriate at this time. Yes, Mr. Woods.
Let's end this thing. I'm going to make a motion. I'm going to make a motion that we go with the proposal from the state attorney, leave everything the same with the exception of changing it from 180 days to 90 days. Am I doing it right? What you're proposing? Yep. Okay. For the time that they're without a license. So that's my motion.
I've got a motion by Mr. Wood, second by Mr. Horn, that state's recommendation be adopted and suspension be for 90 days, not 180. Is there discussion on the motion?
I'll just make one point. Whenever you first came in here and started talking about this, and I opened up the document that Mallory pointed us to, I got to the first line of it, and the first sentence says, 6 complaints of a similar nature were all received regarding the same Respondent 1 broker. I almost felt like I didn't need to go much further than that. If you got 6 complaints filed against you for doing the same thing, it must have been pretty bad.
But there's smoke.
And I still kind of feel
and
that way.
and if you did something, if we had proof that this person did it one time, we probably would at least hit them as hard as we have. And there's proof that they did it 6 times.
So I feel like we need to keep what we got. I appreciate you making the motion. Let's have a vote on it, but I'm gonna vote no.
So,
Okay, Mr. Young, is there other discussion, first of all? Let's roll call this vote. You can start
Okay.
anywhere you want to this time.
Roll call for the Dennis case. Johnny Horn. Fontaine Taylor.
Let me explain that.
Let's make it clear. though.
Okay, if you vote yes, you're for reducing the suspension from 180 to 90.
Okay. Diane Hills.
No.
Did I skip you, Gary?
Yes.
Oh, I'm sorry.
Yeah. Okay.
You are here.
Yeah.
Gary Bloom.
No.
Okay. Diane Hills.
No.
John Grease.
Yes.
Janet DeChera.
No.
Marcia Franks.
No.
Bobby Wood.
yes.
Austin McMullen.
All right, that motion fails by a 6-no, 3-aye vote. Is there another motion?
Wasn't it 7-2?
There are three.
Three? Okay.
Any other motions to be made?
So if there is no motion, this
We're
stands.
we're moving on to the next item.
All right.
Okay, last call. All right, the chair's going to rule that there are no other motions. We appreciate your time.
Thank you.
Look forward to seeing you soon.
With all your people.
Thank you, Mr. Gregory.
Yeah, just bring us a whole courtroom full.
By the way, just as a technical thing, you keep saying June 3rd, but my calendar says June 2nd. Is that?
The hearing would be the 3rd, wouldn't it?
Okay, I just want to make sure we have the date right.
We will.
Okay.
Okay.
Austin, we're coming after you.
Sarah, do you want to come on up? Sarah Page, do you want to come on up? This is Sarah Page. She's one of our even newer litigating attorneys. And she's got she's got a TREC case that's up in litigation. Her question for you is a procedural question, so it should be fairly brief. So I'll let her talk to you about that.
I'm sorry, your last name?
Page, P-A-G-E.
Thank you.
Good afternoon, members of the commission. Thank you for having me. Again, I'm Sarah Page. I'm the newest litigator with the Department of Commerce and Insurance. I appreciate you letting me come before you. The request I'm making today is permission to have a case heard before an ALJ that otherwise would be heard before this commission. The reason I'm making that request is at this point, this case, which I can give you a brief recitation of what that case entails, has 2 opposing counsels on it. At this point, many of the dates for TREC have been booked by cases that other litigators have represented they don't anticipate to settle. Now that Mr. Gregory's case will be going forward, there is a possibility that June 2nd will become available, and if that is true, regardless of how you go forward on this, I will attempt to make sure that this appears before the commission. There are 2 dates that are currently available, July 7th and November 10th, that do not have cases set. However, because of the 2 opposing council members having legitimate conflicts with previously set court dates, they are not available. So for that reason, to avoid having to set 2 complaints next year, I thought I would be wise to come before you and ask to see if you would prefer if I hear this before an ALJ. If you'd like, I can tell you what the matter entails so that you're more comfortable with that decision. This is 2 complaints that come from a licensee and an affiliate, principal broker. In this case, the involves 2 complaints regarding both of them, and these 2 agents represented sellers. The complainant was a second buyer. So the sellers originally sold the house and contracted to sell one of their properties with a contingency clause that had a 48-hour kickout and a allowance to continue advertising. The complainants in this case were second-round buyers that came and put an offer on the house that already was contracted for. However, that contract did not indicate that there was already a binding contract on the house, and the second buyers did not discover this pending contract, if you will, until the second counteroffer. Based on that, this commission has already approved civil penalties of $3,000 plus attending 1 meeting for both the affiliate and the principal broker. So that is kind of a brief summary, but if you have more questions or would like to more details, I can definitely answer that.
And I can also say because this was one that I presented, so it was, since I've been here, this was one where the timeline of events was made all the difference, and it all happened within a very short time period. And so I think that's probably why they haven't agreed to the consent order that they want to go to litigation because it's such a detailed transaction. So Sarah can give you those details if you want them, but I don't know that you want to hear them all again.
But essentially, they sold one house 2 times.
That is the essence of what the case is. So we're definitely, as a litigator, I am comfortable going forward on this matter, and I intend to litigate it. It is merely a matter of, do we want an ALJ to hear it so it can be heard this year, or are you comfortable waiting till next year to hear this matter? And of course, regardless of your recommendation, if a date becomes available before you, I will ensure that we try to set that as such.
So does the principal broker have an attorney? And
They
his
do.
licensee has an attorney?
That's correct.
Okay.
Different opposing counsels.
Do they have opposing views?
They don't. We were actually intending to consolidate these complaints, and they will be heard as one large case. So we intend it will take a full day.
Question?
Move that we authorize it to be heard by an ALJ if it can't be set on our calendar before the end of 2016.
Second.
All right, we have a motion by Commissioner McMullen, seconded by Commissioner Franks, that this commission will allow Office of Legal Counsel to use an ALJ, Administrative Law Judge, in case we can't get on the calendar in 2016. Discussion.
Is there ever a time we add?
Speak up.
Is there ever a time we add another day to our meetings, or to do that ourselves, or what?
I think part of the reason we set a calendar a year in advance is because these judges get booked as quickly as attorneys do.
Correct.
So it's difficult to do it, I suspect.
It can be. It can be. If it was further out in the year, if the commission would be willing to have a special setting, that is definitely an option that I would be willing to fill. And if it was further out in the year, we can make a request to the Administrative Procedures Division to see if they can have a judge added. It may be challenging. I can't promise that they would be able to do that.
And we have people who come from Memphis to Bristol on this panel, so that's hard to add another day, I think.
Well, something you mentioned last month about the number of complaints we're getting. They're pouring it, just coming in like crazy, right?
Well, they seem to be. It's kind of hard to tell if they're continuing to be that way because they aren't necessarily getting referred up to legal in the time frame that they are supposed to be. So it's kind of hard for us to tell at this point.
So we don't have a meeting in December.
Correct.
Is there a time? Is there a time when maybe we ought to think about adding that meeting back?
Y'all are welcome to change that if you'd like. The statute just says you can have meetings as necessary to conduct your business. So if you decide that you need another meeting to be able to conduct your business, then you are welcome to add one. It doesn't have to be in December necessarily. If you wanted to have 2 in August, like you could. I don't know if. I mean, you could kind of do that however you want. We just have to give notice of it.
Of getting these complaints prepared. I don't know. I'm not recommending it right now. I just wonder if that's something. Jenica?
Let me pull up. We have quite a few complaints that are pending litigation. The litigating attorneys are having trouble getting things set, and the problem with that is that the hearings tend to be rather lengthy going through transactions. And so whereas other boards like to stack their docket on the days in front of the commission, it's not so easy to do that with TREC, to have people really on standby, whether or not they're going to be able, you guys are going to be able to hear 2 or 3 cases in one day. I think the most I've seen you do in the 2 years is 2 cases, and it's usually regarding the same transaction, and we like to combine those. This past month, we stacked hearings, and it turns out that only 1 went forward. So deciding whether or not something's going to actually go forward in an appropriate amount of time for another litigator to take that date is complicated.
It's like tomorrow. If we'd had 2 scheduled for tomorrow, then...
Well, and what happened with tomorrow is that the judges came back. We originally had a judge, and the judges came back and said that they will be at a conference this week and they won't be available. And we did have 2 set. It turns out we didn't need them, and they've settled in their own way. But so that's the problem that the litigators are having with getting your hearings done in a timely manner.
Okay. We've got a motion.
Well, can I ask a question to piggyback your December question?
You feel free.
So, Jenica, if we decided to add our December meeting back in, could we just do 2 days of hearing?
If we can get judges at this point, we can try. I don't think that they've been set. You know a little bit more about setting judges, Sarah.
The schedule right now is not officially set. It's been tentatively set with the administrative law judges. But if it was December, I feel if we communicated quickly with APD that they would make that accommodation.
Would it be more helpful if we said, or if the commission said, can you look and see if there are any dates at all available in December? And then if there are, then the commission could decide if those dates would work to have meetings. Like, instead of saying, we want to meet in December on these dates, see if they're available, like, just see what dates are open and then kind of see if that works for everybody.
We could do that because we don't have a December meeting scheduled. So if there's a judge available.
Yeah, because
Like
it may not be the second week like we normally do, but if it's maybe one of the other weeks, if that worked for a quorum, maybe.
Absolutely. Our intention is not to take any hearings from this commission and put them with the ALJs if that is a matter that this commission wishes to hear. So we would make whatever accommodations we can to ensure that that happens. So I'd be more than happy to speak with opposing counsel about their availability in December.
Well, or even just for, not necessarily this case, but any cases that we need to get heard.
Oh,
Do you need a motion or something?
What was the motion we have on the floor?
It's still to be voted on.
Yeah, what is it?
But the motion would work. It's that we
90
sign it to
days.
an ALJ unless we can find a date this calendar year for us to hear it. I mean, that's basically the motion. Let's vote on that, and then we'll talk about December. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. All right, that motion passes unanimously.
Thank you, members of the commission.
Now, just before you go, Ms. Page.
Oh, absolutely. Happy to
Well,
speak.
let's just say,
Sorry about that.
is there a desire by any member of the commission to make a motion related to requesting available dates in December? For
Do you need a motion for that, or is
Well-
that something you can?
I'll look into it. I don't need a motion, but
What if there are 2 days, like December 5th and 6th, that are open right now? Can you tie them up without us scheduling a meeting, or you have to have?
can we tentatively reserve dates? Like, how does that work?
Administrative Procedures Division.
Uh-huh.
We would have to make a request because the consideration is the administrative law judges do hear cases for over 80 agencies. So they do tend to schedule these far out in advance.
Okay.
So it would just be a matter of calling their scheduling director and getting their opinion at this point.
But if they said, like, December 5th is open, if they told us that tomorrow, would we be able to ask, can you hold that date for us?
Yes.
Or do we have to have, like, a specific case number to put on the calendar before they'll hold it for us?
No, you can make a request to have a docket day.
Okay.
And whether that is utilized or not is just a matter of how the cases fall.
Okay.
Great. I think that's good. And
So you don't need a motion?
No, I don't think so.
No, we'll look into it and I'll let y'all know.
All right. Thank you, Ms. Page.
Thank you.
Ready?
Ready.
Are
Okay.
you gonna call somebody else now?
That's it.
Okay. Let's do it.
Any consent order authorized by the commission should be signed by a respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. 2015-02-15401. And the following was presented at the February 2016 meeting. Would you like me to read or just skip to the new information?
Give us a quick summary, then give us new information.
Yes, this was an advertising complaint. The individual the commission found there were 3 different violations. The advertising did not have the firm and telephone number on the website. And then it was, I believe it was updated, but the firm name was not conspicuously on the website. Those 2 violations are not in question here. The respondent asked that I represent this based on the 3rd violation only, which was that The commission found there was an offer guarantee that did not disclose the pertinent details on the face of the advertisement. And respondent believes respondent's offer guarantee was misinterpreted because it's not an offer made to induce a listing contract and is not a guarantee of the sale of the property, but only a guarantee to make an offer on the property, as respondent is also a real estate investor. Respondent states that there's no way for respondent to include the details on the website because there's no way of knowing the details involved until respondent talks to the seller and finds out more information about the property. For instance, the property may need third-party approval to sell, be required to be auctioned, or may be required to be listed, as is the case with FHA foreclosures. Respondent states respondent will always make an offer as stated in the guarantee, since the guarantee does not say that it will be a fair market value offer or guarantee any specific terms. Respondent states respondent has moved the offer guarantee from the website altogether, as respondent has never received a call about it. Respondent states no one was harmed and that respondent's intention was to be truthful in including the restrictions. Respondent states respondent has never had a complaint filed against respondent, and respondent's licensed in 2 states. Respondent asks for the commission's reconsideration on this issue. So I have put exactly what the guarantee states below there. It says the program that guarantees your results. We are willing to place ourselves accountable for the promises we make. So if no buyer is willing to make an offer on your property, then we will make an offer to buy your property. And then the little star below says restrictions apply. Not all properties will qualify due to the type of property, location, condition, age, price range, restrictions of short sale banks, etc., or arm's length transaction requirements, etc. Please contact us for more information. And then I've also stated the rule there, so you can see exactly what the rule states. And it's any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be in writing and must disclose all pertinent details on the face of such offer or advertisement. So the new recommendation is to discuss.
Commissioner Bloom.
Yes, I'd like to make a recommendation that we hold to our original decision.
I have a motion by Commissioner Bloom, seconded by Commissioner McMullen, that the original decision be confirmed. Now, Ms. Hills, do you have discussion?
No, I was just going to say I could offer $5,000 and comply, right?
Yeah, I mean, that's basically what he was saying. Like, he says, I'm not misleading anybody. I'll make an offer. It may not have to be a good offer that they'll want to accept, but.
Okay, further discussion?
And he also said that, he's not doing this to try to get a listing agreement.
Oh, but it's kind of a bait and switch, it looks like.
Why else are you doing it?
Okay.
Yeah.
All right, I sense we're ready to vote. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Number 2, same style.
Yeah, 2015-022-0151. So this complaint was really the things that the complainant was complaining about. We determined in our last meeting that we didn't see any evidence of those violations. However, the respondent in her response stated that an individual was showing properties and that person was unlicensed. So that's what the consent order was for. I spoke to the respondent, and she states that the 35 townhomes in the complex are all owned by one owner and rented out. The assistant reference lives on the property and only unlocks the door to let people see the units. Respondent states this person does not negotiate leases or anything of that nature and is compensated in the form of free rent and utilities only. It would appear to legal counsel that this person falls within the exception in TCA section 6213-104A1E, which exempts resident managers of a residential complex from licensure. So in the original response, she just said that this was a townhome that was being showed by this person. So it kind of made it like when you hear townhome, you think a single family home owned by an individual person. But when she provided this other information, it looks like that's not really the case here. She said they just call them townhomes because they're 2 stories, but really it's a 35 unit, almost apartment complex. So.
Well, the townhome, the land goes with the deed. A condo, the land does not. That's what my lawyer. When we started building townhomes, I said, what's the difference? And he told me that the land goes with it as a townhome. That has been kind of misconstrued and makes people, what does that mean? They think a townhome is just a 2-story unit.
So does this person who has free rent, do they do anything else?
She says she just unlocks the door for them if people are looking at the unit, and then they'll call this person if they need a repair or something, and that person will then call the owner. Like she's like just kind of the.
Do we have proof of that? Because anybody could say that.
No, but I mean, the only thing we had to go on that we thought this person was showing on properties without a license was the fact that she said this woman showed her one of the townhomes.
Do we know if she negotiates leases or anything?
She said she does not do any of
Get them
that.
signed?
She said does not do any of that. That she just helps out because she lives in one of the units.
And did she take the $595 security deposit?
No. Oh, that's what she said. I mean, we don't have any proof we don't have any proof to show that she did anything else. We were the violation from last time was solely on the fact that the woman said the respondent said this individual showed her the townhome. So that's all we were going on before. But in getting this other information, to me, it sounds like she falls within the residential manager exception here.
I make a motion to dismiss.
Second.
Motion by Commissioner DeChara, seconded by Commissioner McMullen, that this complaint, after further review, be dismissed. Is there discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
No.
The motion passes on 8 aye, 1 no vote. All right, item 3.
20150214841. A complaint was filed against respondent by potential purchasers of a timeshare unit. Complainants received a default letter from respondent's financial services manager dated June 26, 2015, advising complainants failed to return an executed contract to respondent and were in default of their compliance agreement and note. Respondent requested that complainants cure the default within 30 days and forward the executed contract. Complainants replied via an attorney, stating that complainants considered purchasing a timeshare in December 2014, but did not agree to any final terms of purchase. Complainants state that they executed a document giving respondent permission to run a credit report, and the salesperson indicated that complainants could return the following day to review the transaction documents and execute the same. Complainants reviewed the documents and returned the following day to discuss discrepancies, but state no salesperson was available to meet with them. Complainants state that no documents were executed or provided to complainants at the sales office. Complainants state that an unsigned contract was sent on or about January 23, 2015, but it contained different terms and property location than discussed. Complainants requested copies of any and all documents that respondent alleges complainant executed, as complainant is not aware of any promissory note, compliance agreement, or closing documents. Complainants state that the complainants have received nothing from respondent, including a timeshare deed, a fully executed settlement statement, or any other document evidencing a transfer of real property, and no money exchanged hands. Complainants also state that it appears respondent opened a credit card in complainant's name, and complainants requested any and all documents regarding the same. Complainants state that respondent will not return calls or other correspondence. Respondent sent a response by and through an attorney who initially stated that more time was needed to respond since the file had to be pulled, but in the interim, the database noted that complainant's account reflects that an offer was made in November to complainant's attorney to cancel the contract and institute a full refund, but the attorney had not responded to the offer. In a subsequent response, respondent states complainant did complete a credit card application and was approved. Respondent states that respondent presents potential customers with various timeshare packages offered by the company which are tied to different interests at different resorts. Respondent states that it is in no way a bait and switch. Respondent states that complainants did not complete their paperwork at the resort on December 23rd because respondent was short-staffed due to the holiday. Respondent states respondent attempted to contact complainants on several occasions and mailed the paperwork, but it was never returned by respondent. Respondent states that the letter was sent to complainant in error since their transaction was never consummated. Respondent apologizes for the administrative error and states that respondent has taken steps to ensure that this type of error does not happen again. And the recommendation is a consent order for $500 for violation of TCA Section 6213 312B20, improper dealing, and $500 for violation of TCA 6213 4031, reasonable skill and care.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hill, second by Commissioner McMullen. The council's recommendation be adopted. Just one quick note: is this a complaint where somebody's upset because they did not get a timeshare unit?
Don't be so surprised.
No, they were complaining because they were told they got a timeshare unit, but they never actually purchased the timeshare. And
Just a credit card. They just got a credit card.
And you know,
I don't think we've ever had a complaint like this before.
well, they were just upset because they were getting these things from the company saying that they they're in default of something they never bought in the first place. And then based on the response that they gave me before they actually submitted their response, and then the response they gave me afterwards was just two different things. It just seemed like weird stuff was going on there.
Okay, the motion's on the floor. Is there further discussion?
Is 500 enough? Yes. Who said yes? Okay.
The second to the motion said yes. All right.
First time that I've been
Let's
here.
vote. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. That motion passes unanimously. Let's do number 4 and we'll take a break.
Okay. 2015021781. Complainant states complainant filed a prior complaint with TREC, which was dismissed and wants TREC to review this complaint with new evidence and legal sources. Complainant's prior complaint was filed against the previous company that managed complainant's HOA. Complainant states that respondent, the current HOA manager, is also abusing and defrauding property owners. Complainant states that respondent is ignoring the HOA bylaws and denying property owners their rights. Complainant states complainant was never allowed to see that the HOA fees were deposited into the HOA account. Complainant states respondent has used the HOA money for...
Move to dismiss.
Second.
Okay, we have a motion by Commissioner Frank, seconded by Commissioner Woods. This complaint be dismissed, and their rationale is we have no authority over homeowners associations, and that's what this is about. Is that correct, Ms. Kirby?
That's correct.
Okay. Is there discussion on the motion? I hear none. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Let's take about an 8-minute break.
John, Shewood Hotel and meeting.
Maybe there needs to be something.
May 4th and 5th?
How do you handle
5th and 6th.
Whatever. Close enough. I'll get there.
The 5th's the only day we're going to be in a meeting.
Item number 5, Ms. Kirby.
201502184041. Complainant states that complainant paid respondent $2,281 for the elimination of a timeshare deed, but then canceled the contract within 3 days required in the contract for cancellation. Complainant states complainant was contacted by email and phone and informed that complainant would only receive a return membership fee of $581, which complainant received. Complainant states complainant is still owed $1,700 because the membership fee was $2,281 according to the contract. Respondent submitted a letter from complainant dated October 26, 2015, stating that complainant was signing a document releasing the complainant from the timeshare and that this will settle the dispute. Respondent states that the complainant is no longer the owner of the property as of April 5th, 2016, and complainant has no more complaints against respondent because respondent has fulfilled respondent's agreement to transfer the property. The membership agreement with a membership price of $2,281 is dated April 24th, 2015. A letter dated April 27th, 2015 requests cancellation of the contract. The cancellation clause in the contract states that the notice of cancellation must be delivered by first-class mail postmarked within 3 business days of the agreement date. The Tennessee Timeshare Act requires a 10-day cancellation period if an on-site inspection of the property has taken place and 15 days if an on-site inspection has not taken place. Refunds must be issued within 30 days of the receipt of the notice of cancellation. The recommendation is $1,000 for violation of TCA Section 6632-114A. Incorrect cancellation must refund within 30 days. TCA Section 6632-121F2E and Rule 1260-06-.04, incorrect cancellation clause, must refund within 30 days, and $1,000 for violation of TCA Section 6632-121F2D, failed to perform any stipulation or agreement made to induce the Commission to issue an order relating to the timeshare program, in Section E.
Move to accept council's recommendation.
Second.
Motion by Commissioner Frank, seconded by Commissioner Hills, that council's recommendation be adopted. Ms. Taylor.
Would this be an appropriate time to add on that they take
I need,
excuse me.
this is just
Would-
against the firm at this point.
Oh, okay. Excuse me. Okay.
Just against what?
The firm. All right, further discussion on the motion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. Number 6.
(2015-0218-261). Complainant states complainant was terminated from respondent's firm because complainant told respondent's preferred title company the complainant would not be using their services anymore if they were not going to fix an error they had made on complainant's client's home warranty. Complainant states complainant was released by respondent because complainant would not comply with the respondent's preferred vendors. Complainant states that complainant should not be penalized for not wanting to use a vendor who is messing things up for the client. Complainant states preferred vendors and point systems lead to a bad situation for the client. Respondent submitted a response by and through an attorney stating that complainant's termination had nothing to do with the use of any vendors or loss of points, but that complainant had only been on respondent's team for just over 90 days, and respondent had several issues with complainant's completion of contract paperwork and had received several complaints regarding complainant's behavior from clients and agents. Respondent states complainant also missed several classes where attendance was required for the agents. Respondent states that 2 clients asked to be released from their agreements with the firm due to complainant's behavior, and in another instance, complainant gave the key to a property from the lockbox to his client, the buyer, before closing without permission from the owner or the owner's agent. Respondent states respondent consulted the attorney for the firm and handled complainant's release as discussed with the attorney, and it in no way had anything to do with the use of preferred vendors or points. Respondent submitted correspondence between complainant and respondent and others in the firm, and complainant and others in the firm, as well as mutual listing agreement release forms that substantiate respondent's response the complainant was terminated for reasons not related to vendors. The recommendation is to dismiss.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hill, seconded by Commissioner Taylor. The council's recommendation be adopted and this complaint be dismissed. Is there discussion?
I have a question. What is loss of points?
They described that the complainant described that the firm has, if you use certain vendors, preferred vendors from the firm, you get a certain number of points, and then if you earn a certain number of points, you get different like prizes or stuff like that.
Like our gas company does that, and you get trips. When you have enough points, you get to go on trips.
Yeah, I think they mentioned trips being some of the stuff you can earn if you use.
That's only contractors. It's not realtors where we are.
It's just like
it is interesting.
an internal thing that they do.
Okay.
They do.
Okay. Nope.
Okay. Before we vote, just a quick question. Mallory, we don't normally handle complaints between licensees and their broker, do we?
Well, it depends on what they're alleging. I mean, if it's about what commission they are owed or something like that, then no. But if it's something that would...
They're being forced to use the preferred vendor.
Yeah, if it's something that violates the Broker Act, some statute or rule in the Broker Act, and it happens to be another agent or a principal broker who's filing the complaint, then we would address that.
Is there any way that we could get information on the history? There's 2 different cases on that principal broker.
Well, I mean, so one of them has been referred to me, but I haven't reviewed it yet. So we just got it. And then the other one, it's been filed. The complaint's been filed, but it hasn't been sent up to us yet. So I don't have any details yet on those.
Okay, the motion on the floor is to dismiss per council's recommendation. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 7.
015-02-18281. Complainants state that on April 13th, 2015, complainants wanted out of their contract with respondent once they found out the company did not advertise with a certain website, which is one of the main online sources for land and farm advertisement. Complainant states that respondent stated complainants had signed a listing agreement. Respondent had already spent time and money on the house, and complainants would have to talk to respondent's boss. Complainant states complainant's wife had already signed the contract, and the respondent threatened with attorney, so complainant signed also. Complainant states that on August 3rd, 2015, complainant asked respondent to remove the property from the market. Complainant states that on August 18th, complainant left the signs under the office carport, and the next day received a text from respondent saying complainant had no right to remove the signs, and respondent was going to contact respondent's attorney. Complainant told respondent that complainant wanted to save respondent time coming out to the house to pick them up. Complainant states that when complainant went to the firm website, their property didn't show up, and respondent told complainant that complainant doesn't know how to use the computer. Complainant states that this is very disrespectful, and respondent is not someone complainant wants to work with. Respondent states that the website complainant is referring to is an MLS, not an advertising service, and the complainant is referring to is not the MLS affiliated with the respondent's local association. Respondent states respondent paid to advertise the complainant's property on several websites which are nationwide. Respondent states that on April 13th, respondent sent complainant a text message stating respondent would take the listing agreement and all of the text messages to an attorney for review to see if they had a valid listing agreement. Respondent states that on April 15th, complainant sent a text apologizing for everything and wanting to stay with respondent. Respondent states that complainant has listed the property with 2 other firms for approximately 3 years with no success. Respondent states that the home is listed at $699,000 in an area that does not have many buyers looking in this price range. Respondent states complainant got very agitated when a showing did not lead to an offer. Respondent states complainant wanted a respondent to list the address of the property as a different town than it is actually in, and would get agitated when respondent would not do this. Respondent states respondent cannot figure out exactly what has transpired, but believes an outside source is undermining the listing agreement. Respondent provided listing agreement and advertising printouts showing the property advertised on several sources. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Frank, second by Commissioner Wood, that this complaint be dismissed per council's recommendation. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those no. Motion passes unanimously. Number 8.
20150-220701. TREC opened a complaint against respondent for failure to supervise respondent in case number 20150218281 above, hereinafter affiliate broker.
Move to accept
Motion
council's
by Commissioner
recommendation.
Bloom.
Second.
Seconded by Commissioner Wood, that this complaint against the supervising broker be dismissed because the complaint against his affiliate or her affiliate was previously dismissed. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Numbers 9 and 10.
2015-02-18341 and 2015-02-18361. Complainant states respondent 1 misrepresented complainant in a contract and was unavailable, which caused complainant to lose money. Complainant states complainant had entrusted respondent 1 with the sale of complainant's home while complainant was in another state, but complainant could not get a hold of respondent 1 or the buyer's agent. Complainant states complainant then contacted respondent 2, who was extremely difficult to communicate with, and lied to complainant. Complainant states that this is documented in a letter sent by certified mail to the owner of the firm, which was signed for on July 20th. Complainant states that complainant has not received a response to this letter. The letter states that respondent 1's communication was so bad, complainant had to reach out to the buyer's agent. Complainant then informed respondent 2 that complainant was firing the firm and the buyer's agent was willing to take over and do the sale at 4%. When respondent 2 asked what could be done to get the sale done, complainant said lower the commission to 4%. Complainant states respondent 2 never said it could not be done. Complainant states complainant did not know the commission had not been changed until receiving the HUD statement. Complainant states that complainant was promised by respondent 1 that respondent 1 would be checking on complainant's house after the showing, since complainant is not in Tennessee full time. Complainant states lights were left on and burnt out, the heater was turned up, and the toilet was used and not flushed. Complainant states respondent 1 moved complainant's electronics into the garage without telling complainant after complainant had told respondent 1 not to move anything in the home. Complainant states complainant was not told when the financing fell through on the first contract. Complainant states respondent 1 sent a subsequent contract to complainant stating it needed to be signed right away, and complainant was on the road and couldn't see the entire contract on complainant's phone, so complainant trusted respondent 1 and signed it. Complainant states respondent 1 failed to tell complainant that it was an as-is contract. Complainant states respondent 1 disappeared after this, and complainant had to call buyer's agent because complainant no longer trusted respondent 1 and thought the buyers had backed out. Complainant states respondent 1 was dishonest and did not have complainant's best interests at hand. Respondent 1 states respondent 1 and complainant were in contact on a very regular basis, communicating almost every day, often multiple times a day. Respondent 1 states a complainant was clear from the beginning about how much complainant wanted to net on the sale, and respondent was able to accomplish this within $200. Respondent 1 states complainant was well informed by the contract and by respondent 1 and agreed to all terms of price with signature. Respondent 1 states respondent 1 always spoke with complainant as to what was in the complainant's best interest and with all terms, and complainant always seemed satisfied. Respondent 1 states respondent 1 above and beyond to represent complainant by marketing the home and even cleaning the home from top to bottom before each open house, since complainant was out of state most of the time. Respondent 1 is caught off guard by complainant's dissatisfaction with respondent's services. Respondent 1 states respondent 1 discounted the commission to ensure complainant received the desired net, and respondents did everything possible to make sure the transaction would be successful for complainant, and ultimately got the house sold just as they were hired to do. Respondent 2 states that complainant contacted respondent 2 stating complainant wanted the house pulled from the market because complainant had gone through too much with 3 offers that had not come to fruition. Respondent 2 states respondent 2 then looked up the file and explained that the house is now currently under contract. Complainant then asked for the commission to be reduced, and respondent 2 told complainant that respondent 2 thought something could be worked out with the respondent 1, but that the commission had been negotiated at 5%. Respondent 2 states they did reduce it to 4.5%. Respondent 2 states that the first contract fell through the week before closing due to buyer's financing, and that it was out of respondent's control because they were not notified until such a late stage of the contract. Respondent 2 states that the second offer never made it past negotiations, and the third offer is the one that closed. Respondent 2 states that the original offer 3 was much higher and contained no as-is verbiage in the final contract. Respondent 2 states that once the home inspection was done, an amendment was added that included the as-is as well as a repair allowance for the buyer. Respondents submitted documentation of email communications between the two respondents and the complainant. None of the documentation supports a lack of communication between any of the three parties. It appears that the notification of the buyer's financing falling through was not in respondent's control. Email correspondence shows that complainant wanted to sell the house as is and was involved in the negotiation of all terms up to the contract up to the final contract. Complainant provided no documentation to support any of the other allegations, and the recommendation is to dismiss as to both respondents.
Motion to dismiss.
Second. Motion by Commissioner DeChara, second by Commissioner Franks, that complaints against both respondents be dismissed per council's recommendation. Any discussion? All right, let's vote. If you're in favor of that motion, vote aye.
Aye.
Opposed, vote no. Motion passes unanimously. Number 11.
(2015-0222-591). Complainant was the purchaser and respondent represented the seller in a land purchase. Seller approached the complainant advising he was selling 50 acres of border complainant's property, and they agreed on a price and measured out 1.5 acres for complainant to purchase. Respondent contacted complainant with the transaction documents, and respondent executed and returned the documents on September 1st, 2015. Complainant states that on September 9th, 2015, respondent contacted complainant stating several people were interested in purchasing the full 50 acres, and complainant once again affirmed complainant's intention to purchase the 1.5 acres on the agreed upon closing date of February 21st, 2016. Complainant states that respondent contacted complainant on October 17, 2015, trying to influence complainant to purchase 0.75 acres instead of the 1.5, but complainant maintained the original offer. Complainant further states that on November 3rd, 2015, respondent advised that respondent did not have any signed transaction documents from complainant. On November 5th, 2015, respondent advised complainant that the full 50 acres was under contract. Complainant states that respondent was unethical and lied during the transaction. Respondent states that respondent listed the property in May of 2015 for the seller. In late August, one of the sellers stated that complainant was interested in purchasing some of the property. Respondent called complainant to acknowledge that complainant wanted to submit an offer. Respondent states that complainant returned the confirmation of agency status on August 27, 2015, and the offer on September 2, 2015. Respondent states that the seller countered, and complainant stated on September 8, 2015, that complainant was out of town and could not discuss it. Respondent called complainant in September, stating that other people were looking at the property and to discuss some of the seller's concerns regarding complainant's funding to close the property, and that the property had been property being landlocked if complainant did not close. Respondent states that complainant advised that the offer would not change, but respondent never received a counteroffer back from complainant. The counteroffer back from complainant. Respondent states that there was no contract or earnest money and that there were showings on the property. Respondent states that the seller was aware that there was no contract with complainant. Respondent states that respondent called complainant a couple of more times to reiterate seller's concerns, but complainant seemed short and annoyed. Respondent states that complainant didn't know when complainant would have the funds, stating that there was an upcoming settlement. Respondent states that seller received an offer in October for all remaining acreage, which was accepted. Respondent states that complainant called in November regarding scheduling a surveyor for the property complainant made an offer on, and respondent advised it was under contract. Respondent states that the documents complainant provided seller were only confirmation of agency and the initial offer. Respondent denies lying to complainant. Office of Legal Counsel reviewed the transaction file. The confirmation of agency form states that complainant, the buyer, was unrepresented in the transaction, and respondent was designated agent for the seller. This was signed by complainant on August 31st and by respondent on September 1st. According to the electronic transaction submission, there were edits made to the lot land purchase and sale agreement on or about September 1st. The initial land lot purchase offer was made on September 2nd. The original offer dated August 28, 2015 is unexecuted. There is a counter offer in the file referring to the offer dated August 28th, stating the purchase price to be $26,000 per acre for approximately 1.5 acres, and the seller reserves the right to continue to market the property to give buyer a first right of refusal. The counter offer is not executed by either party. According to the electronic transaction submission, the counter offer was created on September 8, 2015. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Ms. Franks, second by Mr. Char, that this complaint be dismissed per council's recommendation. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 12.
201502226111. TREC opened a complaint against respondent, principal broker.
Second.
Motion by Commissioner Frank, second by Commissioner Chara, that the complaint against the previous licensee's principal broker be dismissed per council's recommendation. Is there discussion? All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 13.
201502226151. Complainant was the buyer of a commercial property. Complainant states that respondent, who represented the complainant in the transaction, was overpaid by $10,000 and refuses to pay the money back to complainant. Complainant states that the purchase and sale agreement states respondent should have received $10,000, but that respondent was paid $20,000 by complainant at closing. Complainant states that respondent's refusal to pay the overpayment is unprofessional, unethical, and most likely illegal, and respondent's license should be revoked. In a subsequent response, complainant states respondent represented the seller in the sale of the property once the property was foreclosed upon, which is unethical. Respondent states that the agreement states, and complainant also stated in a letter from complainant's attorney that respondent was to receive $10,000 at closing, then another $10,000 and the second mortgage was paid off a year later, plus another 2% after year one. Respondent states that complainant did not live up to complainant's agreement and neither broker was paid the additional commission. Respondent states that had complainant lived up to the complainant's contract, the 2% plus $10,000 would have been paid to respondent. Respondent states that the extra $10,000 at closing was noted to complainant by the seller twice and was also advised by the title company, and complainant okayed the transaction funds to be paid after complainant was shown the closing statement. Respondent states that complainant said respondent could take the extra $10,000 and then complainant would not have to pay him at the end of the year. Respondent states that complainant hired an attorney to make a claim against respondent, but after the attorney reviewed the information, the suit was never engaged. Respondent included a letter respondent sent in response to a letter sent by complainant's attorney that states complainant approved the $20,000 payment at closing and that it would have been changed had complainant instructed them to do so. Respondent states in a letter that the seller is surprised complainant is pursuing the collection of this amount and that the seller was letting rest the collection of the alleged amount due from the complainant in interest and penalty of approximately $52,000. Respondent states in the letter that the demise of complainant's business, the property was a hotel, left many small suppliers in bad shape and that respondent would be happy to offer the alleged overpayment to help these suppliers. Both parties seem to agree that the respondent was overpaid by $10,000. The disagreement lies in whether or not the respondent should have to give the money back. While the PSA has a provision regarding what happens to the contract parties if one party defaults, but does not speak to what happens to the brokers if one of the party defaults. It is also possible that complainant's payment of the additional $10,000 at closing and acceptance of the settlement agreement to include $20,000 commission at closing constitutes a written waiver of the condition that the additional $10,000 be paid after the loan was paid off in 1 year. In addition, complainant signed off on the closing settlement statement for the $20,000 to be paid at closing. The recommendation is to dismiss.
So moved.
Second.
Motion by Commissioner DeChara, second by Commissioner Hills, that this complaint be dismissed per council's recommendation. Discussion. All right, let's vote.
I'm just trying to figure out what happened. So they got 10,000, and how'd they get overpaid the 10?
They're supposed to get paid $10,000 a year later or some distant, and instead the full $20,000 was on the closing statement.
I got you now. Okay.
And they agreed to do that instead of having to wait till the end of the year.
I'm with you.
All right, the motion is to accept council's recommendation and dismiss. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 14.
201502222671. Complainant states respondent conducted improper, fraudulent, and dishonest dealing in a short sale transaction. Complainant states complainant submitted a $170,000 offer on the property for clients on October 8, 2015. Prior to submitting the offer, complainant states complainant had discussed the property with respondent specifically about a low offer of $120,000 by another client, which was withdrawn, and was told by respondent that there were no other offers. Complainant states complainant and clients expected a counteroffer which was never forthcoming. Complainant states complainant's clients said they contacted respondent about a property and respondent was not interested in showing it to them. Complainant states respondent is lazy and rarely answers or returns calls. Complainant states complainant started calling respondent on October 10th to no avail, so complainant called respondent's broker, who stated respondent just had knee surgery and just got married on the 10th. Complainant states that respondent emailed complainant on the 14th, stating complainant's offer was one of two and that the bank would give the respondent a number soon so that respondent could request highest and best. Complainant states that at this point, the property had been on the market for over 5 months, which was ample time to get approved for a short sale. However, complainant's offer was not approved by the seller and the bank, and the bank had nothing to review. Complainant states that complainant requested a payoff amount from respondent on the 20th, and respondent gave a number in the low 200s, even though the original loan was $189,000. In response to complainant bringing this to respondent's attention, respondent stated this was a bad guess. Complainant states that complainant had not received an acceptance, counter, or rejection as of October 22nd, and respondent stated he was still working on it. Complainant states that on the 23rd, complainant called respondent's broker, who was on vacation, and told an employee that complainant needed an acceptance, rejection, or counter that day, or complainant would file a complaint with TREC. Complainant states respondent called back screaming and ranting later that afternoon and provided a rejection with no counter. Complainant states that there was something wrong with this transaction. Respondent states that prior to receiving complainant's offer, respondent had discussed the history of offers on the property with respondent. Respondent states that respondent did speak with complainant's clients the morning of October 5th about another property, which was the morning respondent got home from back surgery. Respondent states respondent gave their info to an assistant to set up a search and have an agent reach out to them for a showing, but it was sent to a bad email address and the lead fell through the cracks. Respondent states respondent got married on October 10th and returned from honeymoon on the 18th, so it is correct that respondent did not return complainant's call on the 10th. Respondent states that a party who had made a previous $160,000 offer on the property wanted to counter, so respondent informed complainant there were now two offers and that respondent would let complainant know once the lender came back with the sales prices they would accept to ask for highest and best. Respondent states that respondent had completed well over 100 short sales over the last few years, and the lenders work on their own schedule and at their own speed. When complainant called after the 14th demanding a bound contract, respondent states that there had not been an acceptance. Respondent states that complainant sent an email on the 20th asking for the payoff amount, and respondent replied with a guess of low 200s as respondent did not know and the loan amount is irrelevant in a short sale. Respondent reached out to the respondent's clients to get the exact payoff amount, and the clients had no idea. A respondent was concerned that complainant called the office employee to demand a bound contract on October 23rd instead of calling respondent, who was in the office. Respondent states that the entire interaction lasted 12 business days from submission to rejection. Respondent states that there were numerous phone calls, 9 emails sent to the respondent from complainant, and 10 responses to complainant. Respondent states that complainant's offer required a financially challenged seller to mow the 15-acre property being sold as is and to reimburse the appraisal fee should it not appraise. That, combined with the fact that complainant was so demanding, caused the seller to move ahead with the other offer that was ultimately approved by the lender on November 6th. Legal counsel asked for documentation showing the other offer existed. There is an executed purchase and sale agreement between the other buyers and the seller dated September 9th, and a signed counteroffer accepted on October 13th. In an email from respondent to complainant on October 14th, respondent states that there are now 2 offers on the property, and once they hear back from the lender, they will call for highest and best. In his additional response, respondent states that the seller countered the other offer because there were some terms of complainant's offer with which the seller felt uncomfortable. Respondent states that seller wanted to hold complainant's offer as backup, but ended up rejecting it because of complainant's ultimatum to file complaint to TREC. From the transaction documents and the email exchanges provided, it appears that as of October 13th, there was a binding contract on the property which would proceed to closing once the lender approved the short sale. However, respondent did not disclose this to complainant and instead told complainant that complainant's offer was one of 2 and that respondent would be calling for highest and best. Legal counsel does not know the details of short sale process, but it would seem that if there is an accepted offer, the contract is binding contingent upon approval by the lender and that any other offers would be backup. The recommendation is a consent order for $500 for violation of TCA Section 6213-403, reasonable skill and care.
I'm having trouble seeing where he violated reasonable skill and care.
Not telling him.
When in fact there was a contract, he still represented that there was no contract.
And maybe the commission can help me understand short sales a little bit better. I did consult someone who has experience in this to kind of help me understand how the offer acceptance part works, since the bank's involved. But in her experience, she said that generally you don't. You send the offer itself to the bank, and then they approve that, not a binding contract. But regardless, this contract was executed, like both parties had signed it. So it was I would think that if that was approved by the bank, if that's approved by the bank, then that contract is binding, and you can't entertain other offers
But the
outside
seller
of that.
signed it, right? The buyer and the seller.
The buyer and the seller signed
Correct.
it, right?
Okay.
But
And then
he
it contingent upon approval with the bank.
Right, but the seller's agent didn't tell him that. He just said, now we have two offers, and I'll come back with highest and best, when there was actually a signed contract already on it.
Well, until the lender approves it, it's not any good. I mean, the seller has to sign the offers saying, I'm okay with this, and then they're submitted to the lender.
Was it on a short sale contract?
It was a regular TAR purchase and sale
So it
agreement.
wouldn't have that language.
Well, there's
would still be
amendments to the
contingent.
contract now. It's not in that contract.
That they should have put.
There's amendments that go with the contract.
There was no amendment submitted with the documentation. It was just a regular old TAR purchase and sale.
But it was contingent upon approval.
It
for
didn't
a
say
short
that
sale.
anywhere.
Ah.
It just was a regular old, but, and maybe I'm wrong about this, I would think that if you have it signed by both buyer and seller, if it in fact is approved by the bank, then that's the offer, that's the contract that they have to go with. At that point, they can't just say, oh, well, the seller approved this, or the lender approved this sale, but we'll also see if you want to come back with something better, because there's already a contract between the buyer and seller on this other one.
Sometimes the banks have wording in there that says that they'll continue to market the property, and if they find a purchaser that will provide them with a better takeout, they'll take that contract, even though they
Okay.
signed the original contract.
Okay. And that may be the case. That did not appear to be communicated to this other agent, which is why I put reasonable skill and care instead of like improper dealing, because I don't know that he was intentionally trying to like hide anything. Maybe he just wasn't clear about what was actually happening with this. Because then in his subsequent response, he submitted a couple different responses because I asked for different things along the way. His last response that he submitted was the only time he mentioned that they were just going to keep this offer as backup. That was the first time I'd ever heard that. Before it was, now we're in multiple offer situation and we're going to ask for highest and best. And then the second response was, oh, well, we're just going to keep that one as a backup.
Well, and sometimes that's what the short sale company will do. I mean, the bank, they'll go ahead and take that first offer that they signed off on, and they'll keep the second offer as a backup.
But there wasn't a multiple contract form either?
No, not that was submitted to me, and I asked for everything I could think of to ask for, but.
Question to me is, would a reasonable professional agent inform a buyer that the buyer and seller, another buyer and the seller have agreed to a contract, but it's still subject to the bank approving it? Yeah. That doesn't sound like that happened.
No. That does not appear what happened.
Okay.
What he told him was, oh, well, now we have two offers, and once I get a number from the bank, I'll ask for highest and best.
Okay.
Be the case either.
Other comments? If not, is there a motion?
Motion to accept council's recommendation.
Are we going to add any education to that, Diane?
Well, let's just see if there's a second to the motion first.
Second.
Seconded by Commissioner Wood. Okay, discussion on the motion.
Are we going to add any education to it?
Well, you've got the floor at this
we
point,
should.
Mr.
I would
Jarrett.
like to amend that to add a minimum of a 4-hour contract class.
Okay, is there a,
And,
She's not finished.
hang on. And a 4-hour ethics class.
Or attendance.
Or attendance at the Tennessee Real Estate Commission meeting
within 180 days?
within 180 days.
Is this
All right, let's
above
see.
All of us
Did
get
that
one
really
written.
well.
Is this above their normal
Yes.
education requirement?
Okay, so let's talk about the motion. Ms. Hills, do you agree to those amendments?
Yes.
And Mr. Wood, are
Yes.
you okay with that? So we've got a motion on the floor that says, we'll accept council's recommendation of a $500 civil penalty and add to that 8 hours of continuing education, 4 hours of which are in ethics, or is it 4 hours is in ethics, and 4 hours in contracts, or the option of coming to the Real Estate Commission to attend a full meeting of the Tennessee Real Estate Commission within the next 180 days. Mr. Bloom.
Yes, can I speak against the motion? I don't think that you will learn anything in either one of those 4-hour courses that's going to help you with a short sale.
What do you think about the main motion? I'll decide what we're going to do.
I'm for the main motion.
Okay, so let's vote on the amendment. We're going to take the amendment and then we'll go to the main motion. Mr. Bloom has indicated he doesn't agree with the additional penalty.
Short sales are a thing unto themselves. And
Oh,
you
is
won't-
there a class?
On short sales?
There are some short sale classes.
Mm-hmm. Yeah.
Well, if you have that.
let's-
Are there
Will
any
you
online
amend
ones
the
in case
amend-
they're?
Yeah, most of them are online.
Okay, maybe that would be the better choice. Are they 4 hours or 8 hours?
4 typically.
Change the contract
Oh,
to
4 hours for short sale seems low.
Change, how about, Mr. Bloom, how about we change the contract class to a short sale class and leave the ethics class in there?
That works for me.
All right, so here's the motion as amended that I think people have come to a consensus on. Accept council's recommendation regarding the civil penalty. Increase the consent order to require 8 hours of continuing education, 4 hours of which is in ethics and 4 hours related to short sales, or attend a full meeting of the Tennessee Real Estate Commission within 180 days of signing the consent agreement. That's the motion that I believe is on the floor. Is there further discussion on that motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 15.
20150222691. TREC opened a complaint against respondent for failure to supervise the affiliate broker in complaint number 20150222671 above. Respondent states that respondent immediately contacted the affiliate broker after being contacted by complainant. The affiliate broker informed respondent that the affiliate broker had informed complainant that the sellers were working on another offer, and it didn't seem that complainant believed there was another buyer. Respondent states that respondent thought the matter was over once the rejection was sent. Respondent states that the affiliate broker has been nothing short of a model agent. Recommendations: a consent order for $500 for violation of TCA section 6213 312B 15 failure to supervise.
I would say that since she's already been, I lost my thing.
Failure to supervise.
Yeah, failure to supervise multiple times, that she needs a more.
Thousands, the max
1,000
we can
plus-
do.
Plus classes. Now,
Let's see.
what classes would be appropriate?
She needs that core principal broker
She
class.
needs some kind of brokerage classes.
No, with that we don't have, right. But what classes would be appropriate?
Well, there is an office management class that you have to take to get your broker's license.
But that's a 30-hour course.
So, obviously, she hadn't learned, or he
How do we- yeah, how do we
hadn't
know it's
learned
a
their
she?
lesson very well
How
yet.
did she came up? We don't know. She.
All this talk is good, but the chair would like to get a motion.
Well, Fontaine's
Okay, I'm working on a
Well, it's
motion.
either, I mean, it's either that or downgrader, or him,
Yep.
whoever it is.
She's got 1, 2, 3, 4, 5
Yeah, because they
already.
keep paying for the failure to supervise, but they
Five.
keep doing it.
Yeah, yeah, absolutely.
Not learning their lesson very well.
Who's making the motion?
Motion to accept council's recommendation and require attendance at a 30-hour office management course.
Or this meeting.
No,
Or come to this meeting or not.
No, or.
No.
Okay,
Need
I
to
got
go to that
30 hours.
course.
So I'll make sure I got the
versus
motion correct. Motion by Commissioner McMullen, seconded by Commissioner Horn, that council's recommendation be accepted with the addition of proof of taking a 30-hour office management course within the next 180 days. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. To the audience, that motion that just passed will be taken by our law director to that principal broker, and the principal broker does not have to agree to it. If the principal broker does not agree to it, that principal broker has a right to have a formal hearing, which we're not having this month, and you guys should be thankful for that in one sense, because that's, as you've heard, usually a day, and it's usually the second day. But if this principal broker says, that's ridiculous, I disagree with it, I want a formal hearing, then we'll have a formal hearing at some time in the future. Okay?
That license might be downgraded at that point.
Never know what happens. Number 16.
20150223991. A licensee filed a complaint against respondent stating complainant was operating an unlicensed vacation rental agency and provided advertising documentation. Respondent submitted a response by and through an attorney and states respondent's company was working with the local government on an ordinance related to short-term rentals but was unaware that there was a state licensing requirement for this type of business in Tennessee. Respondent states that immediately after receiving the complaint, respondent's company began to work diligently to prepare and file the necessary application for vacation lodging service license. Respondent states that respondent's company always strives to be a good corporate citizen in every jurisdiction in which they operate and are committed to compliance with all applicable Tennessee local laws and regulations. Respondent also submitted a letter from respondent's company's legal counsel reiterating that company intends to be a good corporate citizen and had a first-hand role in working with the local government on short-term housing legislation. Corporate counsel states that the company operates in over 15 metropolitan cities nationwide, and for each location, the city, not the state, has dictated the licensure requirement for short-term rentals, and the interaction at the state level has been limited to taxation. Corporate counsel states that the company has taken immediate action to comply with licensing requirements. The company is licensed as a vacation lodging service as of February 29th, 2016, and has a designated agent. The designated agent is a different person than respondent. It appears that respondent is the president of the company, which is located in Washington State. Recommendation is a consent order for $250 for violation of TCA Section 6213-104B. Vacation lodging service must have a license.
Mallory, is it true that the complaint was filed in December of 15 and he became licensed then in February of 16?
That's correct.
So at the time of the complaint, he was unlicensed?
Correct. Well, that's when it was opened with our department. So in December. So it could have come in, before that a little bit, but.
As a matter of fact, this complaint was opened by staff, right?
No, I don't think so. This was filed. It was I believe it was another licensee that turned in information about this. I would also be
brokers in Washington State.
There's no broker. It's a vacation lodging service,
Oh.
so they just have to have a designated agent. And as far as I know, I don't know who this person is. I assume are here, but there's no.
And I'm not good with timeshares or vacation lodging, so to have the license for the firm, there doesn't have to be a broker.
Mm-mm. Vacation lodging services don't have real estate brokers. They just have a designated agent. I would also feel okay about, dismissing this one as well, since they immediately got licensed and took care of that.
Well, this is, to me, opening up a huge Pandora's box, because there's so many people who in Nashville and Williamson County who are doing the little VRBOs and the little short terms, and some are just rooms of their houses.
See, in this particular case, we know more about this than we typically would.
So what is the law on it? If there's a lady next door to me that's got somebody in her guest house.
Well, would be her. If she owns her house, then she can do that. This is when somebody else is doing it.
She couldn't do it from me.
Correct, without being licensed. Yeah.
Can we just talk about a previous meeting? I think it just strikes me as we must have talked to these people face to face previously.
Perhaps you have.
Okay.
I thought that rang for Washington State.
Washington State.
And you recall that what they were doing was renting apartments and then subletting the apartments. Mm-hmm. So they had the lease on the apartment, and they'd lease it for a year and then rent it by the week, or some concept like that. And they were straight. I do recall, if we're talking about the same people, they're very straight with us, and really just found out they had to have a license, didn't know that, and that's when they started interacting with the real estate commission.
And their license got held up because they had to do something about the escrow account.
Right.
That was the
escrow account here.
Right, we
Yeah.
put certain requirements on them as
Yeah.
far as that escrow account is concerned.
And we've received that accounting of their escrow
Yeah.
account.
But they have an attorney who looks into this in every state in which they operate, and they never looked into it in the state of Tennessee.
Not disagreeing with that.
Well, I'd like to
I
recommend.
mean,
that
what their counsel said, and I read this, but she said Tennessee is the only state where it's required in state law. It's in all the other states that they operate in, it's a city law thing, and so that's why they didn't look into state law.
Mr.
Move that
Bloom.
we accept council's recommendation.
Yep. Motion by Commissioner McMullen, seconded by Commissioner Wood. Mr. Bloom.
Well, I wanted to accept council's recommendation at $1,000 instead of $250. They're operating without a license in the state of Tennessee.
All right, so there's an amendment to the motion offered by Commissioner Bloom that the consent order be for $1,000, not $250. Is there a second to Mr. Bloom's motion? All right, since there's not, Mr. Bloom, we'll go back to the motion which is on the floor, which is to accept council's recommendation. Further discussion on that motion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. The motion passes unanimously. Number 17.
20150224121. A complaint was filed by a buyer against respondent who was the listing agent of the subject property. Complainant alleges that the seller of the property provided a property condition disclosure dated May 5th, 2015, which stated that the property was essentially perfect. Complainant states that a home inspection was held on May 13th, 2015, and a previous offer made by a different potential buyer was rescinded based on inspection contingencies. Complainant alleges that after complainant's closing, respondent stated that respondent had neither read the property disclosure, the previous inspection report, nor ascertained the reason for or causes for the previous rescinded offer. Complainant alleges that respondent had notice of...
Ms. Kirby.
Yes.
I'm sorry to interrupt you, but your recommendation at the end of this 2.5-page narrative is to monitor the court. This is in court?
This is in civil litigation, yes.
Move to accept the recommendation for litigation monitoring.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks, that this recommendation by, what are you laughing at, Commissioner Horn? that this recommendation by Office of Legal Counsel be adopted. Is there discussion on the motion? All right, let's vote then. Those in favor of the motion vote aye. Those opposed, no.
Thank you for doing that. I appreciate that.
Thank you for it. Anytime you have one of these real long ones and you've got that at the end of it, highlight it, okay?
20150224181. A complaint was filed by buyers alleging unethical behavior on part of respondent and the listing agent. Complainants state that respondent withheld known issues with the property, stating that there was a prior offer in which seller received a list of 50 repair items pursuant to a home inspection, and the seller declined to make the repairs. Respondent states respondent failed to disclose any problems with the property to complainants, including popped window seals and rotted French doors. Complainant states that they asked the seller for minor repairs and treatment of carpenter ants after the inspection. Complainants also requested $3,500 of furniture, which they agreed to purchase in the contract in exchange for a $4,000 repair of concealed rot. Complainants state that in response to requests, respondent became furious and made 2 unprofessional calls to complainant's mortgage broker. Complainant further alleged that respondent yelled at complainant's agent and called their agent stupid. Complainant states that respondent ordered their agent off the property and complained to their agent's principal broker. Complainants state that they found out respondent had 3 or 4 other deals contingent on the sale of the property. Complainants further state that the home was not professionally cleaned, draperies were removed, chandelier shades were removed, and the gutter was not repaired, and the garbage disposal was not replaced, all in violation of the contract. Complainants further state that the keys to the home were not available until 3 hours after closing. Respondents sent a response stating that the complainants are misinformed and the prior offer was released upon receipt of the inspection report through the though the seller desperately tried to keep the first deal together and performed minor handyman repairs. Respondent states the potential buyers from the first offer would not let the sellers make any repairs. Respondent states many items in the first inspection report referenced upgrades and not repair items or material defects, and the repairs made by the handyman were done prior to complainant's offer and did not affect the property condition disclosure. Respondent acknowledges that complainant's inspection indicated minor wood rot, but it became apparent at the walkthrough that not all had been repaired by the contractor. Respondent denies that the seller concealed the wood rot and states that the home inspector failed to take pictures of all the wood rot and the contractor only repaired what was pictured on the report. Respondent further states that the seller agreed to compensate complainants in the form of furniture that complainants originally agreed to pay for. Respondent states that the seller had the carpenter ants treated and left receipts at the home. Respondent states that complainant's mortgage broker was excellent to work with and acknowledges calling complainant's mortgage broker first for introductions and to discuss wiring funds for closing, and secondly to discuss the resolution to the wood rot after complainants contacted the mortgage broker regarding the same. The respondent denies calling complainant's agent stupid and states that respondent became aggravated when complainant's agent began yelling at respondent in front of the seller. Respondent asked complainant's agent to leave when the conversation became tense and called later to continue working through the transaction after motions were settled. Respondent observed that complainants were not present during this incident. Respondent further states that complainants and their agent constantly threatened to walk away from the transaction to attempt to use it as leverage, and the seller consistently made accommodations to satisfy complainants. Respondent acknowledges sternly, pointing out that parties' obligations and suggested that the complainant's agent involved the principal broker to assist in getting the matter resolved. Respondent further acknowledges contacting complainant's agent's principal broker when it appears that the transaction was in danger of failing. Seller informed respondent that the house was cleaned per the contract and the removal of the draperies and chandelier shades was a complete mistake, but the items were returned immediately. Respondent denies lying about the repairs and states that the complainants were not present during the final walkthrough, but receipts of completed repairs, including the garbage disposal replacement, were provided. Respondent further states that keys were delivered to the complainant's title company with a package from the seller's title company once the transaction was funded. Respondent states that Respondent acted professionally throughout the transaction, even towards the end when things were heated, but the parties eventually came to agreement and closed. Respondent has never met or spoken with complainants and worked amicably with complainant's agent through the transaction. Respondent provided a statement from the seller and correspondence with complainant's agent as well as transaction documents. Respondent states that 3 other purchase and sale contracts were contingent upon this transaction, and respondent advocated for all the closings to occur. Respondent is sorry that complainants were unhappy with the transaction, but maintains that respondent represented the seller in the transaction with the utmost professionalism. Office of Legal Counsel reviewed the transaction documents. The property condition disclosure executed by all parties indicates that the double-paned or insulated windows and/or doors are being repaired. It appears that complainant's inspection report was provided to respondent on May 15th, and respondent acknowledged scheduling a contractor to review the wood rot the same day. There is an ongoing conversation with the agents regarding the wood rot repair and a final inspection amendment. It appears that the parties came to an agreement regarding the furniture on or about May 30th, and the walkthrough occurred on June 10th. Complainant's agent and respondent had a lengthy professional conversation on June 10th regarding the wood rot and the inspection amendment. At one point, respondent apologized for being frustrated and stated that the seller and respondent will do right by complainants if something was truly not done. The gutter and garbage disposal invoice dated May 28th was provided by the complainant's agents, and the parties agreed in writing for the return of the drapes and shades on June 15th. The recommendation is to dismiss.
Motion to dismiss.
Second.
Motion by Commissioner DeChara, seconded by Commissioner Taylor, that council's recommendation be adopted and this complaint be dismissed. Ms. Franks.
Ms. Kirby, you feel certain then that all of the conditions to the contract were met?
So the wood rot part was, that repair was not completed, but once it was brought to the respondent's attention, we saw in the documentation that they came to an agreement that instead of sending a contractor back out to finish the repairing the wood rot, that they would just give them the furniture that they were going to purchase in the first place. So they came to an agreement to work that out. But other than that, we don't have any evidence that that anything else was not completed.
Other comments? Let's vote. If you're in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 19.
20160059991. TREC opened a complaint against
Motion
respondent.
to dismiss.
Motion by Commissioner Hill, second by Commissioner Wood, that this complaint against the principal broker of the previous agent be dismissed. Discussion, per council's recommendation. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 20.
20150224251. Would you like to look at my
I
recommendation?
saw your
I saw it. I
recommendation.
was going to make a motion.
This is another case that's in court. Office
Accept the recommendation.
Office of Legal Counsel
Second.
recommends we monitor this case, consider it a later date. Mr. McMullen, seconded by Ms. Hills, or vice versa, however you want to record it. It's made a motion to accept council's recommendation. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. 21.
20150224271.
Ms. Taylor makes a motion
We've got to
to
read
accept.
the number in.
Oh, sorry.
sorry, I was looking for-
20150224271.
Ms. Taylor makes a motion that we accept council's recommendation,
Second.
and that is properly seconded by Mr. Chara, and we will monitor that litigation. Let's vote. All those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 22.
20150224311. A complaint was filed by previous complainant against respondent who is the previous buyer's agent from the failed transaction, referenced in case number 20150224251 above. Respondent states that respondent entered into an exclusive buyer's representation agreement to represent a couple seeking to purchase a residence. One of the properties of interest was the subject property in which complainant ultimately purchased. The affiliate broker in case 20150224251 was the listing agent, and the relocation company was the owner of the property. Respondent's buyers placed an offer to purchase on September 17th, 2012, which was accepted September 19th, 2012 by a representative of the seller. The binding agreement date states September 20th, 2012. The contract was subject to several contingencies, including appraisal, financing, home inspection, and wood-destroying organism inspection. Upon receiving the inspection report, respondent's buyers opted to terminate the contract under paragraph 8D1, the inspection. Respondent denies involvement in the sale of the property to complainant and had no knowledge of the complainant until after complainant purchased the property. Complainant called respondent in April 2015 asking for a copy of the inspection report. Respondent did not immediately recall receiving a copy, but then later discovered the copy and declined to provide it since it was not respondent's report. Respondent contacted the respondent's client upon complainant's request, but the client also declined to release the inspection report. Respondent admits to a heated discussion and frustration with complainant. Respondent denies complainant's allegation of conspiracy or collusion with the previous agents. Respondent denies concealing information or misrepresenting facts regarding the property. Respondent denies any violation of TREC laws or rules and requests complaint to be dismissed. Complainant submitted additional information stating that respondent told complainant that respondent was unable to get in touch with seller through seller's contact information, though seller's contact information not changed in over 2 years. Complainant provided copies of correspondence with local associations representatives and the 3 respondents in which complainant received the name and contact information for respondent's buyer. It does not appear that this respondent was involved in complainant's transaction and thus would not have information with regard to complainant's purchase of the property. Because complainant was not a party of the transaction in which respondent was involved, respondent did not have a duty to complainant. Recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Ms. Frank, seconded by Mr. McMullen. Or was that Wood? Wood, excuse me. The council's recommendation be adopted, this complaint be dismissed. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Read that number in.
20150224371.
Motion to dismiss.
By Mr. Chara, second by Ms. Taylor, that the complaint against the principal broker of the previous licensee be dismissed per council's recommendation. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 24.
20160032881. Complainant hired respondent to manage the rental of complainant's townhome and alleges that respondent failed to remit rental income for February, March, April, May 2015. Complainant contacted tenant and confirmed that rental payments were made on time. Complainant inquired about the past due rents multiple times. On May 17, 2015, complainant informed respondent that services were no longer needed. After not receiving rental payments and the security deposit, complainant sent a certified letter July 3rd terminating services, but states the letter was returned. After multiple additional inquiries regarding the deposit, respondent informed complainant on or about August 3rd that respondent's office had flooded and respondent could not make the deposit. Complainant requested that respondent forward the security deposit multiple times from May through November and states that as of November 11th, the day the complaint was filed, complainant has not received the security deposit. A copy of the complaint was forwarded to respondent's firm on or about February 19th and was signed for by another individual on February 22nd. As of the date of the presentation, respondent has not responded to the complaint, and my recommendation is revocation. And I got a little gung-ho and forgot to put the violations, which Jenica has written down for me, so I will read them to you now. Because she keeps me in line. 62.
Good job, Jenica. Big job, big job.
6213, 312B5, and 20, which are failure to remit money belonging to others and improper dealing. 6213, 313A2, which is failure to respond. 6213, 403, which is reasonable skill and care. And Rule 1260-02-.09, which is dealing with escrow accounts.
Motion to approve council's recommendation.
Okay, I have a motion by Commissioner DeChara, seconded by Commissioner Hills, that if passed, will revoke this licensee's license. Discussion.
Do you have knowledge how many licensees are under this broker?
I believe maybe one or two. It could, and this person may be the only one. It's a very small firm.
Okay.
It's about to be smaller.
Yeah.
All right, you've heard the motion. Is there any further discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 25.
2016006611. Complainant states that respondent presented complainant with a short sale transaction and requested an $11,000 down payment. Complainant states that respondent represented that the bank was asking for $54,000, but the property was valued for at least $90,000. Complainant states that a tenant, not the owner, was living in the property and paying $600, but respondent represented that complainant could receive up to $900 a month in rental income. Complainant states that complainant wired respondent's firm $11,000 toward the purchase of the property in the amount of $54,000 for a closing to occur in September of 2014. Complainant states that months later it became apparent that the original deal would not work and respondent offered a second plan for a double closing. Respondent states that complainant could still purchase the property at $54,000 and then sell it to the current tenant for $110,000. Complainant states that as of the filing of the complaint in December of 2015, the deal is not any closer to closing. Complainant has requested a release of the purchase and for a return of the $11,000 earnest money. Complainant states that respondent asked in about November to allow respondent to continue to work the deal, and respondent provided complainant with an advance check for $3,000. Complainant states that this check was returned for insufficient funds. A copy of the complaint was sent via certified mail to respondent at the firm address on or about February 10th and was delivered and signed for by an individual on February 12th. As of the date of this presentation, respondent has not responded to the complaint. My recommendation is for revocation based upon 6213, 312B5 and 20, which is failure to remit money dealing owed to others, improper dealing, 6213, 313A2, failure to respond, 6213, 403, reasonable skill and care, and rules 1260-02-.09, dealing with escrow accounts.
Motion to approve council's recommendation with another add-a-girl to Jenica.
Motion by Commissioner DeChara, seconded by Commissioner Taylor. The council's recommendation be adopted and this licensee's license be revoked.
I have a question.
I do too.
Good. Ms. Hills first.
Thank you. So what about the formal hearing set for this year?
Coming.
We don't, it's over?
It's set in August, and we're hoping to move this along and revise the notice if we can, if this consent order is not accepted. If the revocation consent order is accepted, this one, then that would probably change the upcoming formal hearing.
That's why these last two complaints, that's why we wanted to get them presented to y'all as soon as possible, because both of them have formal charges authorized, and so if they don't accept the consent order, which I anticipate they probably won't, then we'll just try to combine the cases.
Good. Did you have something?
No, I did,
Oh,
but
I'm
she
sorry.
asked my question.
Okay, thank you. All right, and we'll remind the audience and commissioners that this is only an offer. We're offering to revoke this licensee's license. He or she does not have to accept it and can have a formal hearing instead. Now, with that said, if you're in favor of the motion, please vote aye.
Aye.
Opposed, no. Motion passes unanimously. Okay. We've had Mr. Gregory's presentation.
That complete the legal report?
Don't tell me we're done.
Yes, that's it.
Hot dang. Thank you, Ms. Kirby.
Unless you want me, do you want me to say something about the consent order log real quick?
About what?
The consent order log. Do you want me
Yes,
to say
I was
that?
hoping you would.
The consent order log, I think maybe it was like this last month too. We've consolidated a little bit, so it's just one spreadsheet here, but essentially it tracks all of the consent orders that are sent out. It tells us when they're due back. They get 30 days to decide if they want to accept it or have a formal hearing. And this is how we keep track of when those are sent out, when they're due, if somebody's paid, and if they have to attend a class or come to the meeting, what dates they have to do that by. So that's what this document is.
Questions about that? We have one more item of business that I know we need to talk about, and that's the May meeting, which is on different people's calendars on different dates. And the question in front of us today is
May 5th or May 12th?
I think May 12th is probably the day on the website, and there's a conflict with that date for several people. And so there's an alternate date available of May 5th, which is a Thursday in Jackson. Is there discussion about moving the calendar officially to May 5th?
It's Cinco de Mayo and it's Kentucky
Would you
Derby.
talk into the microphone?
And it's the
Miss Stein?
Kentucky Derby.
May 5th is the Kentucky Derby?
Yeah, that would.
Oh, the 7th.
6th and 7th.
We're-
And Cinco de Mayo, it's on the 5th.
Does that affect anyone in this group?
Yeah.
Cinco de Mayo.
The Kentucky Derby.
Kidding.
Oh, Kentucky Derby might affect Gary.
It will.
It will.
Yeah.
Of course, he can leave Jackson and head to Kentucky.
So is there a desire to move it from the 12th to the 5th?
Yes.
Then we need a motion let's put on the table here and let's talk about it.
You just say it.
Well, I just want to add that the Jackson Association would like to take the board out on Wednesday night of whichever week we come, but they would love for us to be there on the Wednesday, May 4th, since NAR is the week of May the 11th, or May 12th.
It's going to be a one-day meeting.
I'll make that motion.
You think I should make it?
Yeah, go ahead.
All right, well, I'd like to make a motion that we move the May meeting to May 5th and 6th.
Second.
We have a motion by Commissioner DeChara, seconded properly by Commissioner Franks, that our May meeting be moved up 1 week to the dates of May 5th and 6th. And I'll tell you, there's nothing going to happen on the 6th. Okay?
Well, yeah, if you move it, we don't have the ALJ reserve, so the
Well,
6th when
there wasn't a hearing anyway.
and it is now, well, if you had it on the 13th, a litigator had until the 13th of this month to file. I didn't anticipate, no one had said anything about wanting to file one in Jackson. Sometimes if they have a respondent out that way, they would, but you do have an ALJ reserved right now for the 13th, but if you move it, then I would leave off that second day.
We have ALJ, but no case scheduled.
Yeah.
Not yet, but technically they have until the 13th of April to file the hearing charges. But we don't think that anybody was planning to do that, right?
Okay. So the motion on the floor is to move the meeting to May 5th and 6th from May 12th and 13th. Is there further discussion? Well, do you want a roll call vote, or do you want to see how this goes on a voice vote? Maker of the motion?
Voice is good.
Voice is good.
Okay, we're going to do a voice vote here. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. All right, we're officially scheduled for May 5th and 6th. Staff has assured us that we have a meeting place and hotel rooms, so I think we're good to go.
And please be there by 6 p.m. on the 4th.
Thank you.
For dinner.
All right, any other business? Mr. Young, Mr. White, Ms. Kirby, Ms. Smith-Harris? No other business. All right, let's just go around the horn here real quick. Gary Bloom, we're especially glad you're back. You get to lead us off on any comments you'd like to make.
Oh, I have no comments except it's a joy to be here, and I appreciate y'all accepting me back after 4 or 5 months.
We've had withdrawal pains.
Yeah.
We missed you.
All right, Ms. Taylor,
Well, it's just always a pleasure.
you have
Excuse me.
words of wisdom. People have to hear it.
Oh, well, this might not be the time. It's always a pleasure to be here, and it's always a learning experience for me, too. And it's nice to see what care, I think, people take on making these decisions.
Thank you. Commissioner Horn?
Yes, I'd just like to say, thank the Lord that Gary's back.
Amen.
And with us. And somebody asked me early this morning.
You're getting ready to give us something deep and intelligent, so get up here
No,
close.
this is just common. But anyway, they asked how did I enjoy the laws being not a realtor. And I told them it didn't bother me at all. I enjoyed them. But this afternoon, they all began to sound the same. I thought I heard that one the last time I was here.
Get used to it. Commissioner Hills.
No, thank you. I'm so glad my left hand is right here. And if you're a broker, don't forget your privilege tax, June
God,
1st.
Why'd you bring that up?
I'm just in case. I don't want to be.
Because you can't renew your license if you
No,
don't pay
without
it.
it. So, yeah.
All right, thank you, Diane. Austin, you were exemplary today, sparring with those attorneys.
I enjoyed getting to participate in the TAR forum that they had for us a couple of weeks ago, and appreciated the invitation, and as usual had fun today. Glad to be back. Thank you.
We are glad you're back as well. Commissioner Wood.
I have no wisdom today. I'm good.
Thank you.
I'm
Ms.
done.
Franks.
I just say travel home safely. It looks like it might be getting a little bit rough, so. And I appreciate everybody that's here today.
Chara.
Well, I hope you've all learned something, and I do appreciate you being here as well. And Gary, I'm so glad to have you back.
All right. You all need to make sure you sign out. Everything else I wanted to say has been said. Travel safely and have fun.
And you don't have to come back tomorrow.
They had that figured.
I'll be out of here.
They had that figured.
I'll send it to her.
Send it.
Good to see you.
All right. Mallory, are you going with us on Wednesday?
She doesn't like us.
You read it? I'll send you info to my house too.
Hey, man.
Where's your son?
What?
Son in the building?
What?